for a parking problem.
Or in your 23?
Yes, that's where I'll get a 28 from my truck when you're ready.
Go ahead.
Line truck, White Lincoln X-ray 985 should come back up next.
Toyota 2000. Patrick Spalding.
10-4. If you just throw a little note in the, something like that, I'm going to be leaving a note on a vehicle so they can verify it.
Rockingham 505. 505 ends of vandalism case for Athens. Complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
Forgive that's a 32.
10-4. 532, you're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4. No, 3 and Depot Street. Truck away entering 5.
7435?
10-4.
10-4.
You go 643 again.
143.
You go with that 43 you had. I didn't hear any, but I had just looks like we do.
10-4, I just wanted to know if you should be put back 76 to Cavada Circle or to the subject's address.
Yeah, I'll be 23 back on that found property case, and I'll be 76 to the Williams Road address to see if I can find the emergency.
10-4. 449 1120.
449, 1121, thank you.
10-4.
Code 4. 4.
Alright, we have 535.
Yeah, that was a great coach.
535.
Should be. Got no environment inflict into the house. I'll slide up that way.
Caller is now been able to close the front door. He's now pounding on the door, trying to get in still. No flight floor, blood dark here, got tight shirt on. Number 21 is on.
Switch is on, here comes the throttle. Chevy breakers in. We have separation. Inboard and outboard, they're on. We're coming forward with the side stick. Looks good. Roger. I've got a blowout. Vapor 3. Pitch to 0. Pitches out. I can't hold altitude. Correction. Alpha 4 is off. Electric emergency. Flight call. I can't hold it. She's breaking up. She's breaking.
Good afternoon, everybody. What a beautiful day outside. Just incredible. It feels like spring is finally here. And potentially a beautiful day inside the courthouse in Dedham. And we'll be streaming this at 2. I am going to go to Fox 25's channel to stream it. But if the volume is not working, I'm going to grift on the grifter. I'll go to his channel. He's certainly generated plenty of material out of me. He does get the Zoom link, so it seems to be the audio problems are a little bit less since he puts in the Zoom link. So if I do have to go to that, let me just thank him ahead of time. Thank you for hosting the show with the Zoom link, Grifter, and I will be there on your channel at 2 if need be. Thank you. Let's say hi to everybody. This is going to be, this to me, this hearing, I think this is the hearing that has interested me more than any other hearing so far. I mean, this now, of course, a lot of times it ends up being disappointing, right? It doesn't go where you think it will. And I think what we're going to hear today is going to be subtle too. So it's going to require a lot of analysis, interpretation to try to figure out what's really going on here. But I think it's going to be incredible. So, hi, Lori. Good to see you. Julie, good to see you as always. I'll be doing Julie, I'll be doing, and everybody else, a double show today because I already haven't had a show scheduled for. I didn't create the show yet, so it's not in the notifications. I'll probably create it right after this one ends. But I'll be going on sometime around 4:45, maybe 5 o'clock, to discuss the Evansdale, Iowa murders. This is a really important case to me because just going over it, even setting up the pictures last night, this was the kind of thing that I swore I would never do anymore, is cover any of these cases with kids. You know, it makes you go through this. I just find it so unpleasant. You go through the anger and then you have tears in your eyes. These kids should be in college now. This is Elizabeth and Lyric with their names. I think 8 and 10 or 8 and 11. They were cousins. They were abducted off their bikes. So more than likely, now this is a cold case. So more than likely that killer is still alive and awaiting justice, and he's still a threat. And this case has been largely forgotten since Richard Allen was arrested in Delphi. So, and looking at this, I don't want to reveal too much right now, but, we're going to have to be careful the way we cover this, but we have a suspect that I feel just logically so confident that this must be the guy, but that's not to say that there's any actual evidence against him, so you can't name him. But what we're going to do over a series of episodes is leave a trail of breadcrumbs for people that want to find him. I'm not trying to lead anybody towards harassment at all. I don't know. We're trying to handle this in the best way we can. So also on with me at 5:45 will be prisoner Bill Noguera. Now, I know people have mixed feelings about this. Bill is a brilliant mind who understands the minds of these types of killers because he spent 40 years with them on death row. He's still in jail. He'll be calling from prison. But the purpose of these meetings and these discussions that I've had with Bill over these last several months is to try to gain a better understanding of killers in the hopes that you can move the needle forward towards helping to capture some of these guys or prevent them. He has actually helped solve an old cold case. We just can't talk about that one because Netflix has the rights and there's a book coming out. So when the book comes out, then we'll be free to talk about it, but we're handicapped right now. But he has applied himself and his knowledge, his tremendous brain and his knowledge towards trying to solve these cases. And so I assigned him this case a few weeks ago, and he's picked it up very quickly. Naturally, he has a lot of similar thoughts to me as to how to go about solving this case. So I love having these discussions with him because his mind just really is. It's great at both of us together can kind of seize on what's important and create lists and eliminate things as being unlikely. And it's been very effective. And it's not necessarily that we need to solve the case. I don't have those kind of resources. But if you bring a little bit of attention to these things, you never know who else is going to pick up the ball and take it a step further. And that's what the hope is, because especially seeing this case being forgotten, these girls would be in college now. I mean, just unbelievable to think about. All right, so let's get to the hearing coming up today. Oh, I'm going to finish saying hi. So hi, Julie. Hi, Lori. Eldon, love to see you, but be good, my man. All right. I know you like to crack wise, and some of the jokes land and are funny, but just make sure you don't offend anybody. But good to see you, though, just the same. Emily Suzanne down in Tennessee, good to see you. Emily, so it's Lyric and Elizabeth. They were cousins. I think Elizabeth's last name was Collins, and I'll pull it up after. I forget. I love that name, Lyric. Forget her name, but they were abducted on a beautiful July day, early in the afternoon, on a bike path. Their bikes were found later that day, along with Elizabeth's pocketbook and her phone that was thrown into the woods. But this is a wide open area near a lake, near a highway. Very brazen, bold crime. Their bodies were found in December of that year in about 20 miles away, in a very obscure hunter's region. It's called Seven Bridges, not Seven Bridges. I don't know. I forget the name. I'll have it after, but it's a specific wildlife area that is very infrequently. It's not a camping ground. It's a place really just for hunters. Although the local high school there, for years, those kids in high school, that was their party place. They'd go smoke joints out there and maybe bring a keg of beer or something out there. Kind of typical thing, but it's a very small high school. The average graduating class is only 28. So you're talking about so whoever took those bodies there had to be familiar with the region. And there aren't that many people that would be familiar with those particular woods. And so it seems very likely that it's someone, that's a really small town where that was. It seems likely it was someone that graduated from that high school. And that's a small list of people. So that's a really short list to work off of. And so if you can find some connection between someone from that high school to the area of Evansdale, which is 20 miles away, or some other connection to the case. See, I'm already putting out that trail of breadcrumbs for you. It's again, you don't want to accuse innocent people. This is what's going on in the Karen Reed case, right? Innocent people being accused despite no evidence. And so in this case here, yeah, there is no direct evidence that leads to this particular suspect. So but he has inserted himself into the case too. So I'm not saying that makes him a fair target, not at all. I don't know. So we'll discuss this and we'll go forward on it. But so for today's hearing, which I think, like I said, this is the one that interests me really more than any recent hearing. I mean, so there's an article today in the Boston Globe. I'll pull it up for you guys since we got time. All right. Hopefully you guys can see that. But anyways, so here's Karen coming out of court. Federal probe of Karen Reed murder case, highly unusual, legal experts say. And keep in mind, today's hearing, I won't say this in this article here, involves the Globe. The Globe's lawyers have motioned to the judge to unseal some of the impounded documents related to the federal investigation. And amazingly, and revealingly, I think, the judge immediately ruled that she wanted a hearing as soon as possible on this case. And she said she wanted it as soon as Tuesday. Well, today's Tuesday. the trial starts a week from today. A week from today. And she wanted this hearing before that. That's got to tell us something, right? That's important. That has to tell us something. Let me just check quick to make sure. I'm just checking to make sure the mic is working. But Eldon says, "Let's be honest. Eldon equals viewers." See, now that's a good comment. That's why I like you have a sense of humor. Just a lot of your comments, I can't highlight or replay because you do cross the line sometimes, brother. Even when you cross it, it might be funny, but I can't let you do it here. So, but thank you. Eldon must equal viewers. But we've only got 88 here right now, so not a lot of viewers, Eldon. So go and get your mob and bring him in. So anyways, the judge has ruled that she wants to hear what the people that created this motion, the Boston Globe, that want to know more. They want to get parts of this federal stash of documents unsealed. They want to know what precipitated this investigation into the investigation of the murder of John O'Keefe. And they want to know what type of seemingly improper, but certainly irregular communication has been going on between the feds and Karen's defense team. And I think the judge wants us out there too. And that's why she's called this hearing. And it's not, it's like she could have wanted this out there after. She could have ruled on this without a hearing, or she could have delayed any hearing on this until after the trial. But that she really expedited this thing to get it out a week before the trial. That's telling, because I think that, and we'll see in this article I'm going to read to you in a moment, just the very existence of the federal investigation interferes with the trial and interferes with the justice for John O'Keefe. And we'll see if she talks about it, but I don't, all indications is that she hasn't seen any sign of a conspiracy or a cover up in those documents. And I think she wants it out there. But you get into a lot of really precedent-setting issues here related to what is proper, what can be revealed, what can she do. She wants to be balanced, and her job is to make sure there's a fair trial here for Karen Read. That's her job. And so to the extent that this federal investigation that the defense team seems to have pretty much ordered on their own, and that they were leaking the existence of this federal investigation through their blogger and then lying about it or deceiving the court about it, these things affect the fairness of the trial. So I think this is why the judge is holding this hearing beforehand. And she has asked the plaintiffs to send, I don't know if that's the right word in a motion, but the motion is probably a better word. I don't know, maybe one of our lawyers can check in. But she's asked the Boston Globe to inform the U.S. Attorney's Office of their motion, which is a little strange to me. I don't know why the judge just wouldn't send that information to them themselves. But I think what she's been unable to get, she can't force the U.S. Attorney's Office to send someone in to explain their actions. They've been invited into court and they've refused to come in. They've refused to communicate with the DA's office. They're just being the feds, like, okay, we're above all you guys and we do what we want. And the law doesn't apply to us. It's not much different than the Soviet Union. We can do what we want. We don't need warrants because we don't need subpoenas. We don't need court supervision of the actions that we take. So, for instance, we can ask the phone companies and the communication companies, the data companies, to give us information. We're only asking it to them, right? So there's nothing wrong with that. But of course, they comply all the time because you don't want to be against the federal government. And if nothing else, it's expensive, right? It's easier to just comply and send over the information. But that seems to me to be a pretty clear violation of our privacy, especially if it's being abused. And it does seem to be being abused. So the Boston Globe says a federal investigation into allegations of a police cover-up involving the 22, we already know all that, will likely have an impact on so this is their first paragraph, that this federal investigation will likely have an impact on the upcoming murder trial. That's powerful stuff. And that gets to the heart, I think, of why the judge did this here. And this, it seems to me that this feels like the fingerprints of friends of Morrissey who are um, probably pretty well plugged into the globe. But I'm not accusing anybody of anything, and I'm not saying there's anything even wrong with that, because at this point, the only way to really keep the feds aren't accountable. The only way to keep them accountable is through their own agencies. The Inspector General's office and the ethics office have to investigate these things. You can't force the feds into doing anything. It's a pretty low jet going over here. And the only way you can really get those agencies, move them to do anything, is political and public pressure. That's it. And those two things go hand in hand. So I think what we see here is certainly the public pressure aspect of it. And like I said, I suspect that there's a political aspect to this too with Morrissey. Morrissey is someone that I've been told all the way since last summer is not someone that is in any way powerless. He's been in office for a long time. His district, his county is right outside Boston. A lot of cities that are a lot of the main cities are intricately linked to Boston. So he's a player, and he's been there long enough. So he's not powerless. He can make things happen to a degree on his own too. So going on with the article, so Reed's case appears to mark the first time in recent memory the U.S. Attorney's Office in Massachusetts convened a grand jury to investigate the state's handling of a murder prosecution while the trial is pending. This is according to several prominent criminal defense attorneys. Brian T. Kelly, a former federal prosecutor who served as the chief of public corruption in the U.S. Attorney's Office, said it's highly unusual, but that doesn't mean they don't have the power and right to do it if they think there are federal crimes occurring. Well, sure. I mean, there's no question that they have the power to do things. They can launch an investigation. But the U.S. Attorney's Office and the agencies, the investigative agencies under it, mainly the FBI, these are extremely powerful agencies. And in this day of data, they're very intrusive in getting that data and getting our communications. And so if you believe in civil rights, if you believe in a free country, you don't want a federal government that is unaccountable. So it should be accountable as much as possible to the courts. So if they're going in there and getting messages from private citizens, there should be a warrant or a subpoena process where it has to be approved by a judge. And it also should be the kind of thing where later on, there's a tricky issue, but you want things to be made public later on, or at least if the people that you've been investigating, if they demand to see what you've done, they should have the right to do that. Because what you have here is a strange situation where the very existence of this federal investigation is useful to the defense to this point, in the sense that just by saying it's under investigation, it creates doubt. But if they don't find anything, that's also inculpatory to the defendant. If their main theory is that John was killed inside the house and the feds dug hard and they didn't find anything, we should know what they looked at. So, for instance, if they looked at all of the communications of the people that are suspected of being involved in a conspiracy, we should know that. If they looked at those communications and just found nothing, and therefore that's not included in the information that they turned over to both parties and the judge, we need to know what they looked at. We need to know not just what they found, but what they didn't find. That's very important in terms of fairness to those people. Now, I said it's a tricky issue because, generally, when not just the feds, but any prosecutorial agency is investigating suspects or people and they don't indict, if they don't have a grand jury indict, then that stuff generally is kept secret. And the reason is to actually normally to protect those people. because just the very notion that you have been under federal investigation leaves you kind of tarnished. It tarnishes your reputation. And so that's the reason why normally these things will be kept secret. But in this case here, because these people have already been tarnished because all this stuff was leaked through the defense agency, then that reason for keeping things secret no longer applies. So it's important, assuming that these, let's call them the potential victims here of this unwarranted obtaining of their communications, those people should have the right to demand to know what the feds found, if they choose to do that, because that's for their own protection. And they can say, okay, yes, the feds looked at all our communications, and because right here now what you have is just kind of hanging in the thin air. It's hanging above them. Say, oh, we found this one 22-second call between Higgins and Brian Albert. Okay, then we need to see the whole picture in order to protect them or find out if there was something suspicious going on. But if they found no other communications that were suspicious, and they looked at all Brian's communications, and both Brian Higgins and Brian Albert's, then the fact that they found nothing else needs to be put out there, because that protects them, that exonerates them. But we're not getting that, because we're only getting this one-sided thing where the defense gets to pluck out the one little sentence that serves them, and then they put it out there. So that's unfair, and it's very intrusive on the part of the government that they can do this. So continuing with the article, the year-long federal investigation into the state's prosecution of Reed has not led to any federal charges. Now, the burden is on the Norfolk District Attorney's Office, this is Morrissey, to prove that Reed killed O'Keefe. Jury selection is scheduled to begin next Tuesday. Michael Morrissey wrote letters to the Justice Department last year raising concerns about, quote, the unprecedented use of federal power to interfere with a state homicide investigation. That's big. I understand people think Morrissey's corrupt. Okay, let's get to the truth, because the idea that you just want to assume that Morrissey is corrupt, or assume that the state police are corrupt, when in fact the federal agencies can also be corrupt. And there's such a long history of it, between the false Russiagate stuff into Trump being a Russian spy. Just incredible. I mean, it doesn't matter to me what someone's opinion is on Trump, whether they're pro or against. There's no doubt that they weaponized the agency for political purposes, and they found no evidence that Trump was a Russian spy, and he's not. We've seen the Whitey Bulger case, the corruption of the feds. There's just so many examples of it. Again, I'm not smearing the federal agencies. I'm saying nobody gets the benefit of the doubt. Nobody. The prosecutors don't, the state police don't, the local police don't, and neither do the feds. And that's to me, that's the logical place to be, is that probably most people that work for these agencies are good people just trying to do their job, and they do care about justice and fairness. But there's certainly plenty of examples in all of these situations, state, local investigators, federal investigations. There's plenty of examples of corruption. So we shouldn't just, if we care about our rights, we have to hold all of their feet to the fire, follow the evidence, and be careful about assumptions that we have. So I find it amazing that how many people on the Free Karen Reed side just have no questions about the feds. They have no problem with the feds getting everybody's communications. Suddenly the feds are these knights in shining armor. That stuns me. It stuns me, especially since a lot of the Free Karen Reed people are Trump supporters. I mean, so certainly if you're a Trump supporter, you understand. If you're in any way a Republican, you understand that you need to be skeptical of the federal government. So why do you just suspend that here? Is it just because you really need there to be a conspiracy here for some reason? So I hate to say it that way, but I think that's what is the case in a lot of people. And of course, there's confirmation bias once you've bought into something, but you have to have some common sense that what you bought into was highly packaged by a defense team, and that's what they do. That's their job. But you should have some skepticism of that and say, okay, we're not really hearing the prosecution's case. And so why would we just, and there's a lot of strange things going on with the feds here. And now that they've turned over their 3,100 pages, and there seems to have been absolutely nothing in that. So that has forced people to say, well, they haven't revealed, like Sean saying, well, they haven't revealed all their information. Why? Why wouldn't they? It's ongoing. Well, they've been looking hard for over a year. They've interviewed the troopers, all the witnesses. They've got the data. What's left? What's left? Is there really likely to be anything else? Continuing, the investigation presents Reed's attorney with an unusual advantage. This is important. The investigation, this is from a defense lawyer, presents someone who used to work for the federal government, for the U.S. Attorney's Office in the Corruption Division. The investigation presents Reed's attorneys, and there's a lot of mistakes in this article too. Like this is small, but attorneys, they have an apostrophe S when it's just supposed to be a plural. But the investigation presents her attorneys with an unusual advantage. They may use evidence that was gathered by federal prosecutors and recently turned over in the state case to attempt to challenge the credibility of some of the state's key witnesses at trial. So that's powerful, right? I mean, so if you could just, any defense team, if they could just use the federal government as a wing of their team and force people to testify again in front of a federal grand jury and get access to the data, I mean, you'd want to do that, right? It's like, seems like a no-brainer. It's like definitely something you'd want to do. However, if you're going to treat it fairly, and I think this might come up today, we'll see. It's going to have to be really subtle. We'll watch for it. If you're going to use that as a tool to help the defense, it needs to work both ways. So if the feds ran an investigation that was predicated on next to nothing and found basically nothing, that in itself becomes inculpatory to the defendant. So what's the requirement on that? You know, is the fact that they found nothing, is that something, that can be reported to the jury? Should it be reported to the jury? I don't know. It's a really thorny issue, because finding nothing is not the same thing as specifically finding something that was inculpatory. But that's another question here too, is we don't know, as Larry said, we have no idea if the feds, what percentage of their material they actually turned over to us. It could have been 5%, it could have been 95%, or we just have no idea. And that's what I mean about accountability. So clearly the feds, once they went down this road, they had a vested interest in trying to show there was a conspiracy. And as this has become exposed and their operations have seen more and more suspect, now they really have they have skin in this game in a big way. So they really need to show that they need to find some kind of cover up. And that's even if they don't have a corrupt connection on their own to Karen or one of the attorneys. And we don't know that, right? That's something we'll find out. It was very unusual that Karen and her team could just walk in there and get an appointment and get an investigation launched seemingly on the thinnest of pretenses. The fact that Michael Proctor Michael Proctor knew his wife, or his sister was friends with Julie Albert. I'm not saying that that's not relevant, but it's very thin if that's the basis for launching a federal grand jury. And that seems to be all there is. Nothing about the weird data that Rich Green found existed at that time. So let me just check in chat and make sure something hasn't happened with my mic coming apart yet. All right, so everybody can still hear me. All right, good. Oh, Tom is back. Tom, good afternoon. Thanks for showing up. Good to see you. Tom had told me he was running some errands and would be back in time. Thank you, Tom. All right, so continuing with the article, it's very rare and very messy to launch a federal investigation into the handling of an active state murder investigation, said Zachary Haffer, a former federal prosecutor who served as chief of the criminal division of the U.S. Attorney's Office. One of the reasons it's so rare is all the practical complications, he said, noting that federal and state prosecutors are compiling reports and taking statements from the same witnesses during their simultaneous investigations. Let's see, then it goes into the case. They mention state prosecutors insist there's overwhelming evidence implicating Reed, including O'Keefe's DNA found on the broken taillight of her car. The state medical examiner found was likely that John was incapacitated by severe head injuries and hypothermia was a contributing factor. Meanwhile, Reed's lawyers say he was severely beaten inside the house and attacked by a German Shepherd. I don't think they're going to say that stuff anymore. That's just been so thoroughly debunked by the canine testing. But they can say it. They can say whatever they want, but they risk really getting the jury to tune them out. The U.S. Attorney's Office and the FBI declined to comment, of course. However, it was disclosed during the state court proceedings in Reed's case that all of the people who were inside Albert's home around the time of his death were subpoenaed to testify. And that includes Colin, who was not in the home at that time, but had been there shortly before. During a pretrial hearing last month. All right, so this is, again, I don't know. I guess the Globe still frustrates the hell out of me with their bad reporting. During a pretrial hearing last month, Yannetti said federal authorities hired crash reconstruction experts who concluded that O'Keefe's injuries were inconsistent with being struck by a car. Well, that was actually not a big deal, but Alan Jackson that said that, not Yannetti. But state authorities alleged that O'Keefe suffered serious head injuries after being struck by Reed. The DA's Adam Lally said that, so the attorney, that Adam Lally, said that the documents that the Fed documents were largely consistent with the state's theory. There was no fight, no attack. The federal crash reconstruction report was among some 3,000 pages of documents, including grand jury statements by witnesses. So they have that report, as we know. And what we need to see is exactly who did that reconstruction and what did they really say. Again, I want to just emphasize that the feds have, the thing that goes on in trials is that both sides, the government and the defense in any trial, kind of know how to get witnesses that will support their case. I think it's especially true with defense teams because money can buy whatever, there's probably a little bit more of a burden on prosecutions to not do that, on government agencies, but they do it too. So, and I said the feds, they have a huge interest here in wanting to find that there was a conspiracy. But at this point, I have no reason to doubt the integrity of the report. What I do doubt is if Alan Jackson has actually accurately described it, because he's famous for taking one word or one sentence off a report and mischaracterizing it. And that's exactly what the judge warned him last week in a motion against dismissing this case, in a warning that was clearly sent towards Jackson, who was mentioned in the sentence before. She's warned him against distortions and mischaracterizations of facts based on impounded documents. So that's clearly, at the very least, if you want to say it's this applied to both sides, yes. So somebody is distorting and mischaracterizing the federal documents. But the Lally didn't really say anything, hasn't said anything specific about the federal documents. So even if you, for some reason, don't think that was self-evident, that the judge was aiming that at Alan Jackson and Yannetti, just logically, you can deduce that she was, because Lally never has just said vague things about the federal documents. He hasn't said anything specific. It's the defense that is making all the specific claims. So we're not sure which document or which claim the defense made that is a mischaracterization and a distortion, but we can guess that it probably has to do with that accident reconstruction, and it probably has to do with the 227 search. But we don't know for sure until we'll know soon. Those documents were impounded by the judge who is and were not made public, but they may be used to question witnesses. So this is something that's an advantage for the defense because they're going to try to find little inconsistencies between the testimony of the witnesses between the state grand jury and the federal grand jury. And there's always going to be inconsistencies. And to most of the time, to the average person, you'll say, well, that's very minor, but they're going to take it and blow it up. And we have to understand in the public that we're very vulnerable to that kind of stuff. That a tricky defense lawyer can take something in our eyes and we can go, wow, that's a big deal. But we have to learn how to be more skeptical. Just like I said before, if you walk onto a little used car dealership, you walk onto that lot, and that guy says, oh, this car's never had a problem, and this car, has got great mileage, and blah, blah, blah. You have to learn to be a little skeptical. Continuing. So, Tracy Miller, a longtime Boston criminal defense lawyer. She said the federal probe of Reed's case is unusual because it's happening simultaneous with her state prosecution for murder. And she says, I'm surprised they, meaning the feds, didn't let it play out. So that's something we can debate, right? Would have been more fair. It certainly would have been more usual that they wait until the trial is over and when they can look at everything. But you could make the case that that might be unfair too to Karen, because once you are convicted, it's not easy to get a new trial. So, but it is unusual. So she says it's unlikely the federal investigation will impede the murder prosecution, but it certainly complicates it. And you can't really say that it won't impede it. It already has. We already saw the U.S. attorney was on the phone with Karen's defense lawyers in late November and was telling them to try to get a delay in the trial. So, I mean, there's been a lot of unusual communication and interference and leaks. We don't know what the impact of that is going to be on a jury. She said the federal investigation absolutely helps the defense in Reed's case because the prosecution's key witnesses have previously testified before the federal grand jury and may be cross-examined about any contradictory statements. So that's what I said. She says it's very hard to be consistent. So there are going to be inconsistencies in testimony between what they told police and what they told the feds and what they told the grand jury too. So you have basically three different testimonies from these people, what they told the police, what they told the state grand jury, and then the federal grand jury. And so you're going to try to isolate any little inconsistency. Longtime criminal defense attorney Martin Weinberg said every federal investigation doesn't uncover evidence of wrongdoing. It simply means the U.S. attorney had some basis to begin an investigation that would substantially overlap with a traditional state murder case. At its roots, this is a classic murder case. He said, can they prove what they charge? Is this woman innocent? And if guilty, is it voluntary murder? So that was the article in the Globe, and we're going to be hearing from the Globe shortly. Just going to check in to see if anything's going on yet in terms of a hearing. The hearing is scheduled to start at Okay, it's scheduled to start at 2, and it doesn't seem to be any courthouse cameras on yet. So we'll keep talking. All right. So somebody sent me an interesting article on geofence and the constitutionality of geofence warrants. It says Google's database contains detailed location records on hundreds of millions of devices around the world. The database is connected to Google's location history, which collects data when people use apps such as Google Maps or any app that you have on your phone. The data is stored indefinitely and goes back nearly a decade. So this is what they use, and it's a very powerful and important tool So it's got to be balanced off against our rights. But so, for instance, if somebody is killed in the house across the street, they're going to get the geofence to try to find out who was there. But it's a tricky process we have to protect, because normally you need a specific piece of information to get a warrant. So if I suspect that my neighbor was across the street during the time of the murder, I can't just go and grab his communications, or I can't just go and if I'm the police, we can't just go and break into his house and investigate to see if he's got any evidence in there. You need to have a warrant to search his house. You need subpoenas to get information on these things, and that means a court has to approve it. That's what protects our rights against illegal search and seizure, and those are fundamental rights of ours. In a typical case, Google provides the police with an anonymous ID number for each device found within a geofenced area, plus information about exactly when and where within the fence each device was seen. Next, the police identify a subset of those devices to ask for additional information on where the devices traveled over a period of time. So someone is murdered across the street, they get the geofence. Maybe they don't know exactly what time the murder took place, so they get the geofence, say, within a 6-hour period. And so people might be coming in and out of the house. And so Google will send the information about those phones, but it's anonymous at that point. And so there's a process that is trying to protect people's rights. So the police will identify certain phones and they'll ask for more information. So where did those phones go? Did that phone, where else did it go? Did it get in the car and drive off? Did it, anything look suspicious? And they're trying to build a case where they can unmask that phone. So if they have someone that they consider a suspect, the police may also unmask certain anonymous users and provide more detailed information about them. But they aren't required to get a subpoena for that unmasking. You're trusting the law enforcement agencies, the federal law enforcement agencies, and Google to protect your rights without any other kind of accountability, without any court that has to look at a warrant or a subpoena. I could make the case that there might be some limited use for that. I mean, obviously, we don't, you got a situation like, for instance, we're going to discuss later, the Evansdale murders. If you could geofence that, they were taken on a bike trail in the public. So if there was phones that were on that trail at that time, yeah, you want police to be able to get access to them, but there has to be some limitations to this. So for instance, it says in this article, the government used geofence to identify over 5,000 devices at the U.S. Capitol during the January 6th riot. That's a lot of phones. That's a lot of devices. And you don't really know exactly what these people were doing. Many of them were just came across it and didn't know what was going on and walked through, thought it was open. The Fourth Amendment protects us, persons, houses, papers, and effects, from unreasonable search and seizure by the government. A government search is presumptively illegal without a warrant. That's the law. That is the law. And I've noticed in this case that free Karen Read people just don't care. They're so determined to want anything that can support this conspiracy that they don't even have a question about whether the federal government should be able to do this. And not only that, they're not even accountable to us later on, So we're just checking to see. Looks like still nothing going on with the hearing. I mean, I just find that troubling. I would be troubled, obviously, if there was any evidence of the state police planting evidence in this case, and they get no benefit of the doubt from me. And I am troubled when I see what, at least now, before we've had a chance to see a full explanation, when I see aspects of the case that look troubling, like wrongdoing, maybe, but more just like inefficiencies, things, things that look like the investigation was not that good. Now, some like I've said many times, a lot of that's going to happen in every case, and a lot of that stuff is going to be possibly explained later, right? But that doesn't mean we need to hold all police agencies hold their feet to the fire for stuff like that. But I don't know why you want to give the federal government a pass here where they can just do whatever they want. So, and what is debate? And even more scary is I want to, Olivia posted on this. I put something yesterday about the feds basically saying the same thing that, you need to, the federal government needs to be accountable. And, oh, get the wrong thing on. Hold on 1 second. I got to find her exact comment. All right. So, and I just really am having a hard time maintaining respect for her after comments like this. She says, you lose your right to privacy when you're involved in a murder. When the feds have evidence of your involvement in murders, you really screwed. I'm sorry. She said, when the feds have evidence of your involvement in a murder, you're really screwed. Stop being painfully ignorant. Stop being so painfully ignorant, she said to me. When do you ever lose your rights? Okay, you never lose your rights. I don't care what evidence they have against you. Your rights mean they have to get a warrant. That's your rights. You don't lose those. You don't lose your rights until you're convicted of a crime. Then you lose your rights. But until then, you have your full complement of rights. You have your full presumption of innocence. All right. And in this case here, it's even worse because what she's saying is that evidence of involvement in a murder is not something that was gathered by any official agency, but something that was a case that was made to them by a defense team and thinly made. So based on that, a defense team walking in, which, my God, if every defense team can do this, there's going to be a huge line at the U.S. Attorney's Office tomorrow. It's going to be a huge ass line. I mean, are you kidding me? They get to just defense team gets to just walk in and use the federal government as a weapon, and because of that, all these people surrender their rights. You get to go after Kevin Albert's phones, all his communications, Brian Albert's, Brian Higgins, Colin Albert's, everybody's without any warrant, without any oversight, and they never have to answer to this. Are you kidding me? I don't really understand it. I mean, this too is like Karen has a right to hire PR people. I don't know that Olivia is being paid by Karen, but she seems like a professional paid PR person the way she covers this case. And I think maybe we have a right to know that. So when Alan Jackson goes out and makes insinuations or claims about this case, okay, at least we know he's a paid member of Karen's team. So don't we have a right to know that too, Olivia? I don't know if you're here at all, but I mean, don't we have a right to know if you're a paid member of the team that's putting out bullshit like that? If it's just your opinion, great, but it really doesn't seem like it. It just feels like you're a paid PR person for them, because I used to see a lot of intelligent comments by you by the beginning, and that comment there I don't think something ate your brain. So I just think you're grasping at straws here, and you're saying things you don't mean. So Aiden also replied to that article. He said, I quote, funny, you weren't so concerned about my civil liberties when they took my phones, computer, and raided my house. He's talking about me. Unlike the people whose civil liberties you're defending, I didn't have a dead cop on my lawn, and I didn't lie to a state grand jury. Well, I am on the record, actually, Aiden, of saying it's on Boston. Oh, thank you, Tom. All right. Oh, shit. I didn't know it was already on. All right, we'll pull it on right now.
grand jury testimony. And here, we submit that the detailed opposition, the 49-page opposition to the defendant's motion to dismiss, contained a significant amount of references to grand jury testimony. So I can't pretend I know what's in the impounded papers, but it does seem reasonable for me to suggest that that disclosure does mitigate the extent to which the rule of grand jury secrecy applies. And the other factor I would cite here is that these materials were submitted to the court as grounds for a ruling by the court, which the court made in denying the motion to dismiss the indictment. So to that extent, it is that the materials are sort of the classic judicial document which the public has a right of access to. The last thing I'd say on this is that, again, I haven't seen what's impounded, but the alternative argument I'd make is if there is some type of sensitive grand jury material which is not already in substance been disclosed, then an alternative available is to redact just those portions of the documents and allow the rest to be made public. So that's sort of my pitch on the grand jury issue. The other issue I and obviously there has been a lot of publicity about this case. That's just true. Commonwealth's opposition. And obviously there has been a lot of publicity about this case. That's just true. But the SJC has said that even in high profile cases, voir dire and jury instructions can be sufficient to protect the defendant's fair trial rights. The other two things I'd say here is I think it's significant that the defendant apparently has said she takes no position on it. So there's less of a concern, I'd say, about the defendant's fair trial rights being prejudiced. And from a legal perspective, I'd also say this. There is, and we put it in our brief, case law that says a closure order, an impoundment order should be effective at what it's trying to do. And in the fair trial context, the Press Enterprise case we cited, in that case, it was whether a pretrial hearing was going to be open or not. And the trial court judge closed the hearing, finding that there was a reasonable likelihood that an open hearing would prejudice the defendant's fair trial rights. And the U.S. Supreme Court said, you have to go higher than that. It has to be a substantial probability that the defendant's fair trial rights would be prejudiced and that the closure order will be effective. And here I would say that given the publicity that this case has engendered, the notion that the incremental effect of releasing the motion papers on the motion to dismiss, that would pose a substantial likelihood of a threat to the defendant's fair trial rights. I'd say, again, I don't have the benefit of seeing the papers, but we'd suggest that's not sufficient to justify a continued impoundment order, given the Commonwealth's filings and given the filing and given the fact that the motion has been ruled on.
All right. Thank you very much. Ms. McLaughlin, I know I have nothing in writing from you, but I know that you're getting ready for trial on Tuesday. So
yes, Your Honor.
That's fine. I'll hear you.
Your Honor, essentially the Commonwealth takes no position on this motion. The Commonwealth received the confidential federal materials pursuant to a signed protective order that the Commonwealth has signed, that all filings made to this court that reference or include any references to the federal investigation would need to be filed, impounded, and under seal. Therefore, that what the Commonwealth has done as it is a party to that protective order. Your Honor, I'm unaware if we've previously filed the protective order. If Your Honor has not received that, I can file that
I have not.
Okay, then the Commonwealth would move to file the protective order pursuant to an impoundment order of this court. That's
Are you going to come back in on that, Mr. Albano?
I should look at it first.
Your Honor, within the protective order, it does reference the jurisdiction of any disputes arising out of the protective order would be before the federal court. Therefore, essentially, the Commonwealth takes no position, but is bound by the federal protective order that was endorsed by Judge Casper on February 20th, 2024.
I'll hear you, Mr. Albano.
If I have it straight, then if the Commonwealth's not, there is a distinction between documents filed with the court and documents in the custody of the Commonwealth and the defendant. And I wasn't aware of Judge Casper's protective order, but typically, in my experience, the protective order says you, the parties, cannot release this information. And this one apparently said, and by the way, if you file it in court, you should file it under seal. Having it been filed with this court, however, it is this court's papers, not the federal court's papers. So I don't, while of course one would take into account the federal court's protective order, I would say, and God, I hope I haven't read it, so I might be wrong, but I would say the protective order binds the parties, not this court.
The protective order indicates that not if we file it, we should impound it, that if we file, we must impound.
So that's been done already?
That has been done, Your Honor.
All right. Does the Commonwealth, I would like the Commonwealth to address the concerns that we have on me releasing these state court pleadings. Are you bound by the protective order such that you can't even address that because they tell you that you have to go to federal court to address that?
The way the protective order is written indicates that if any party seeks to modify the protective order, the exclusive jurisdiction would be within the federal court.
So neither party is seeking to modify the protective order.
The Commonwealth has not sought to modify any protective order, nor has any party filed a motion to intervene in the federal court or seek this material from the federal court or address the motion before the federal court.
So why don't I have the authority to hear you today on the release of the state court materials that you filed, but I have referenced in my decision?
The Commonwealth, can essentially takes no position on what your authority is and what your role within the state court is. The Commonwealth can only represent what order it is bound by.
So, Ms. McLaughlin, I want to hear you on whether or not there is a docket number 201 that are the Commonwealth's grand jury minutes. What's the Commonwealth's position about me releasing those?
The grand jury minutes?
Yes.
The Commonwealth would oppose the release of any grand jury minutes prior to trial. No, the trial is imminent. These same witnesses who testify before the grand jury are anticipated to testify within the upcoming weeks. The release of their testimony prior to that trial may, don't want to cloud anyone's memory or anything that they previously testified to. The public will have the right to all that information when the witnesses take the stand. Under Massachusetts law, grand jury minutes are secret, and the Commonwealth would oppose any, release of the materials that went before the Norfolk grand jury.
Okay. So when I read Mr. Albano's motion, I focused on the paper numbers that he cited, or everything that the Commonwealth and the defendant filed under seal. You all followed your protective order that I do not have to follow. You all followed the protective order. And I considered those materials and I referenced them. They were critical in my decision and I referenced them in the decision. So That's what I am focusing on.
If those portions, whatever, Your Honor, its findings, the public has the findings made by the court. The witnesses would testify to that, their personal knowledge shortly. So the Commonwealth, as in any case, would object to the release of any grand jury minutes.
But regarding the pleadings?
Regarding the pleadings, if Your Honor is inclined to release pursuant to this motion that the Commonwealth, really does take no position on, redactions could be made to any references of grand jury materials that, the Commonwealth takes no position on what Your Honor's authority is, but to the point that when we filed the materials, we were bound by this protective order.
So they were impounded.
Yeah, so perhaps the redactions may be appropriate. It's a unique circumstance.
It is a unique circumstance, and I understand the position that the Commonwealth is in, and I understand the position the defendant was in and prudently decided not to pursue anything in court, but you had no choice. You had to be here. So, Mr. Albano, do you believe I have the authority to do with these documents that you've requested what I want to do with them and what I think the Massachusetts law governs?
I do, Your Honor. I think, again, I'll go back, track down that protective order, and I'd be happy to submit a supplemental filing. But as I stand here today, I don't understand how a federal court judge can tell a state court judge what to do with the state court's files.
For a case that's on for trial next week. So I share your view. I do not have any case telling me that I have to listen to what they say I should do with this case. And I'm not going to put the Commonwealth in the position to ask them whether they agree with me.
Please, no, Your Honor.
Or not. So as you all know, this case is going to trial next week. So although the Globe recognizes the secrecy of the grand jury proceedings, it is requesting that this court unimpound 14 days of grand jury testimony on the basis that some grand jury testimony and exhibits have been disclosed in a public court filing, and therefore the interest in grand jury secrecy are overcome by the public's right of access to court records. While it's true that some grand jury testimony has been previously disclosed to the public, I can tell you because I've read them, the majority of testimony and exhibits have not. In particular, the request encompasses videos of SANE interviews and testimony of witnesses not mentioned in any public filings. So although the SJC has recognized that a limited amount of disclosure of grand jury testimony may be justified when there has already been public disclosure of that information, the Globe has not directed this court to any case law suggesting that where some grand jury information has been publicly disclosed, all grand jury testimony and exhibits lose their secrecy. And that point is clearly made in a case that, the Carol DeMady Stewart case. So the Globe newspaper versus police commissioner of Boston. It's a case that plaintiff's counsel was Mr. Albano. So should the Globe seek grand jury testimony of a specific witness whose testimony was summarized in public court filings, the court would consider such a request. However, the only part of the witness testimony, my reading of the case law, that would be subject to disclosure is that which has been summarized in a court filing. So I am prepared to release subject to redactions, and as if you don't have enough on your plate, Ms. McLaughlin, I am going to give the Commonwealth until tomorrow morning at 11 o'clock to make proposed redactions. The defendant has waived any argument to this motion, so it's up to the Commonwealth. So I am inclined to release paper 199, which is the defendant's motion to dismiss. There are attachments to that by way of exhibits that are with it. I am not going to release what's docket number 201, the grand jury minutes. I am not going to release the grand jury minutes. I am going to release paper number 228, the supplemental memorandum in support of defendant's motion to dismiss, though it has actually a different heading. And I'm going to release the Commonwealth Supplemental Memorandum in opposition to defendant's motion to dismiss, docket 232. So it doesn't give you a whole lot of time, Ms. McLaughlin, and I do know just that there were police reports attached to the motion to dismiss the Odell motion.
Okay.
That include dates of birth and addresses of witnesses, so I will redact those. Certainly, you're not interested in those, Mr. Albano. So I need to redact any identifying information, and what the Commonwealth might think should not be released pursuant to this order. It doesn't stop you from filing a motion to intervene in the federal court, obviously, for anything else. All right.
Understood.
All right. Okay, can you get it to me by 11 o'clock tomorrow morning?
Yes, Your Honor.
Thank you. All right, thank you very much.
Thank you, Your Honor.
All right, so Jim, we're going to take a recess before we do our other stuff, okay? Tori, we all set? I can take my computer? Thank you.
All right, please.
Okay, this is, we're doing this on Mike Crawford's channel, so thank you, Mike. I want to go back to the beginning.
That's not clear that the...
When I read Mr. Albano's, nice to see you, Mr. Albano. Okay. So before we begin, I did receive this morning a motion from Ms. Reed's counsel asking to waive her appearance today, as well as her counsel, stating that she takes no position on the motion and does not wish to be heard on the motion through counsel. I allowed that motion. And I also want to let you all know that when I read Mr. Albano's pleading, it was clear to me that the U.S. Attorney's Office was an interested party. So I, as you know, ordered the moving party to give notice to the U.S. Attorney's Office if they wanted to come here and be heard. They have sent a letter to me this morning that was docketed and put in the file, and they're not here to address this motion. So with that, I will hear from you, Mr. Albano.
Thank you, Your Honor. I don't want to repeat what I put in the brief, so
That's okay. Say whatever it is you want to say.
I thought maybe I should focus on the two issues that I expect are most significant here. One is, it seems clear that the impounded materials do include some grand jury materials. And obviously, there's a general rule of grand jury secrecy. That we would submit is not always the case. If the witness is impeached with grand jury testimony, the trial isn't closed. If there's a perjury conviction, or perjury trial rather, that's not closed, even if it's based on grand jury testimony. And here, we submit that the detailed opposition, the 49-page opposition to the defendant's motion to dismiss, contained a significant amount of references to grand jury testimony. So I can't pretend I know what's in the impounded papers, but it does seem reasonable for me to suggest that that disclosure does mitigate the extent to which the rule of grand jury secrecy applies. And the other factor I would cite here is that these materials were submitted to the court as grounds for a ruling by the court, which the court made in denying the motion to dismiss the indictment. So to that extent, it is that the materials are sort of the classic judicial document which the public has a right of access to. And the last thing I'd say on this is that, again, I haven't seen what's impounded, but the alternative argument I'd make is if there is some type of sensitive grand jury material which has not already in substance been disclosed, then an alternative available is to redact just those portions of the documents and allow the rest to be made public. So that's sort of my pitch on the grand jury issue. The other issue I seems to me is relevant is the fair trial rights with a trial coming up and a disclosure of what has till now been impounded material if it's not in substance the same as the Commonwealth's opposition. And obviously there has been a lot of publicity about this case. That's just true. But the SJC has said that even in high profile cases, voir dire and jury instructions can be sufficient to protect the defendant's fair trial rights. The other two things I'd say here is I think it's significant that the defendant apparently has said she takes no position on it. So there's less of a concern, I'd say, about the defendant's fair trial rights being prejudiced. And from a legal perspective, I'd also say this. There is, and we put it in our brief, case law that says a closure order, an impoundment order should be effective at what it's trying to do. And in the fair trial context, the Press Enterprise case we cited, in that case, it was whether a pretrial hearing was going to be open or not. And the trial court judge closed the hearing, finding that there was a reasonable likelihood that an open hearing would prejudice the defendant's fair trial rights. And the U.S. Supreme Court said, you have to go higher than that. It has to be a substantial probability that the defendant's fair trial rights would be prejudiced and that the closure order will be effective. And here I would say that given the publicity that this case has engendered, the notion that the incremental effect of releasing the motion papers on the motion to dismiss, that would pose a substantial likelihood of a threat to the defendant's fair trial rights. I'd say, again, I don't have the benefit of seeing the papers, but we'd suggest that's not sufficient to justify a continued impoundment order, given the Commonwealth's filings and given the filing and given the fact that the motion has been ruled on.
All right. Thank you very much. Ms. McLaughlin, I know I have nothing in writing from you, but I know that you're getting ready for trial on Tuesday. So
Yes, Your Honor.
That's fine. I'll hear you.
Your Honor, essentially the Commonwealth takes no position on this motion. The Commonwealth received the...
Okay, so that was the stuff we heard. I want to thank Mike Crawford of the Young Jerks for, unknowing to him, lending us his stream, but he had good audio there. So thank you, Mike. We should give credit where it's due. Mike Crawford of Young Jerks did have the stream. So let's give credit where it's due. So really fascinating stuff here. I took notes, so that's what I'm looking at. No, I'm not looking at text messages from the McAlberts or whatever other weird things people want to say. But I keep a notebook here. It's kind of old school, but I take notes. So I'll have to go over and watch this again. And I really can't. I'm hoping that some of the a lawyer, for instance, Lawyer Lee does a good job on these things. If you follow her on YouTube, hopefully she'll take this on tonight. This was really fascinating stuff, but you really need a lawyer to get at it. But it looks like what the Globe had motioned for specifically was the motion they want the motion to dismiss by the defense unsealed. And then they also want the opposition to that motion from the state. So the issue with that is those motions involved federal materials, including federal grand jury testimony, which is normally something that's highly protected. And it was among the different issues here. So there's a protective order that both sides had to sign, that they would not reveal any of the federal material. But everybody seemed to agree that this does not apply to the judge. We have in the United States dual sovereignty. You have the federal system and you have the state system. And each has their own separate dual sovereignty. It's not necessarily that the feds are always on. This is something that people outside of this country don't understand. So it's not like the feds are automatically above. No, it's just there are areas of the law that the feds are interested in, and that's their sphere. And there are areas that the state is interested, and sometimes those spheres overlap. But there's still dual sovereignty. So within their own systems, if one of them is filing charges or indicting or investigating, they have the judge is exempt from the protective order. So, but they still want to try to follow the principle of the rules, and the principle would be the sacredness of grand jury testimony. But there are circumstances in which that becomes less sacred because it's already been revealed in other ways. So let's skip to what the ruling was. Well, so first of all, the defense didn't send anybody here. They did send. I don't even think they sent a letter. They basically just sent a note, a note that we're not opposing any of this, and they didn't send anybody. The prosecution sent McLaughlin. She is not opposing it either, although she did feel obliged to oppose any release of grand jury material. But basically, she's not opposing it either. So what can you take from that, right? So neither side seemed to not have anything that really concerned them or worried them or some reason to oppose this stuff. That's really interesting, right? I think the main reason is, I don't know. I'm not sure what it means, actually. I was going to say, I think there's probably no bombshells in either side. And we already know that, right? We've already can tell that. But you could also make the case that if you're one side or the other and you oppose the release of this information, maybe you're worried that it makes it look more suspicious that you got something to hide. So I don't know. And especially when the judge is going to rule unless you actually have a valid argument against it anyways. So so the judge has ruled that the defense's motion to dismiss and then the follow-up opposition by the state is going to be made public, with the exception of they have until tomorrow morning to redact federal grand jury testimony. I'm not even sure if it's all the testimony or just certain relevant testimony. Not sure what they'll go by on that. So, but it just says redacting the grand jury material. So that makes sense. So, but the judge said there are witnesses that have not been mentioned in court that are in this federal material. There are also documents, reports and things like that were not mentioned. So, we don't know. It doesn't sound like, well, what we're going to get. So we're only going to get the stuff that either side chose to put in their motions. But that's all the important stuff. So we're not going to, so if there's any piece of evidence that tends to show even the possibility of a cover-up, obviously the defense is going to include that in their motion. They had a motion and then they had a supplemental motion where they added to it. That's now going to be made public. So will we get the full report? For instance, according to Alan Jackson, the feds hired an independent accident reconstructionist. And then he gave us his own interpretation of that. And he said that this independent reconstructionist found that John's injuries was inconsistent with the damage to the vehicle. Now, I don't think we're going to get the actual report necessarily, but we're going to get a lot more, because what we're going to get is whatever Alan Jackson and the defense chose to outline in more detail, but then, and very importantly, whatever the state chose to reply about. And that'll give us a lot of insight, right? So if Alan Jackson says essentially what he did, I don't know. It's limited, because the thing is so let's say, so if Alan Jackson made basically the same, if they made the same statement in their motion about the inconsistency of the injuries, it's not necessary that the state had to rebut that. So they may not actually say much. So we may not learn much about that unless the judge, and it doesn't seem like here, this is here, that the judge is going to also have that, whatever report the feds had, that will be included in this. I didn't hear her say anything like that. So that's very disappointing, because the state is only going to have to, they didn't have to show that Alan Jackson was lying or distorting or misleading on that. All they had to, those motions were based on an Odell, and it was a very specific thing. And what it does is you have to be able to show that the grand jury was shown false evidence, or evidence was withheld from them in a way that might, in theory, have influenced their vote. So, for instance, 227. The defendant could not say 227. This is evidence that shows, our client was innocent, because Rich Green, the defense analyst, found that evidence a year after the grand jury was shown its evidence using a different version of the software. So it was a difficult hill for them to climb. They had to actually show that somehow the state could have had that result and could have sent it to the grand jury. So that doesn't mean that 227 still couldn't be very exculpatory, but the state did not have to reply to that, because that'll be dealt with in trial. So if part of the argument that Alan Jackson made was that the feds had supposedly found the same thing, that there was a 227 search. But again, the state did not have, the state had in no way had to rebut that. So they may have a rebuttal but they didn't need to put it there, because all they need to do was explain that they could not have produced that result in 2022 because they were using the latest version of the software. So short of having a time machine, they could not have used a 2023 version of that software. So it's really interesting, right? You get into this legal aspect of the case where the state is not holding a trial, through these motions. They're replying to very specific aspects of it. So we may still, even if with the stuff that's going to be released very soon, ordered by the judge, we may still not see until the trial what those actual reports were by the FBI on 227, or by the independent reconstructionist that they hired on the accident. We may not see that until the trial. I don't think we're actually going to see any of that tomorrow. I don't already come in the coming week, but it was still, I don't know. I really can't wait to hear some lawyers talk about this, because clearly the judge wants this stuff out before the trial. Why? What does she want out? And why does she want it out there? I mean, I think it's fascinating to me, and we're trying to read the tea leaves on this. And of course, I'm just an old bartender, so you may be stuck with me unless you can find, but it's very hard to find anybody that wants to talk about this in any objective way. So hopefully we can find Lawyer Lee. We'll talk on this tonight. So let's see what else we had on this particular thing. So again, the judge does not have to follow the protective order, so she can release federal material. So I'm curious here if she will release anything else, but it sounds like she just wants to release those two motions, but there may be a lot of stuff in those motions that could be interesting. The U.S. Attorney's Office, again, had a chance to send someone and chose not to. They did send a letter. So apparently there's a question. So sorry, Tom, I'm just trying to go through my notes first, and then I'll look back at the questions. But I'll glance back and see if I can find. I don't see the question, so you can repost it, Tom, and I'll watch it from your reposting of it. So the U.S. Attorney's Office, amazingly, they don't want to have to answer any questions in court on this case. The feds can't tell a state what to share. Everybody seemed to agree on that. They talked about, now obviously some testimony has already been exposed. So The main thing is to protect grand jury testimony. But if it's already been revealed in some way, then you're not really protecting him by not necessarily by not releasing it in more detail. So it should be interesting. So I'll just, oh, okay. Let me answer David's questions too. And let's see, Tom, and then Tom didn't ask the question. He asked if he could ask. Okay. So if he's gone, he's gone. David says, so it took us until 2:23 to be able to find the deleted text. Yes. Yes. You have to understand, David, that defense teams, I don't know if you've ever been on a jury. And so I have been on juries. I've got another one coming up in May. And when I remember one of the juries I was on, they asked so this was a plaintiff suing a defendant for money. And so the plaintiff brought in a doctor to testify extensively about the supposed injuries and suffering that the plaintiff was experiencing. And so the defendant the defendant was able to bring out exactly what it was a doctor that was brought in to testify, exactly what his employment history was. And over the last several years before that testimony, he was not practicing any medicine. But he testified in numerous trials. So he had become a professional medical testifier, which tells you a lot of what you need to know. He's obviously, defense teams wouldn't be, or in this case, plaintiffs wouldn't be hiring him unless his testimony was useful to them. He knows what they're looking for. Well, Rich Green is the same way, and defense teams in criminal cases are the same way. They know how to find the guys that they need. And that's very, very, so again, I'm not questioning Rich Green's honesty, but he's going to just run a program and highlight the things that help the defense. He's not trying to get to the truth of whether or not there were deletions or a 227 search. What he's trying to do is just spit out the software, and if it runs something that helps the defense, stop right there. There's no reason to dig anymore because he's done his job. He's given them what they want. Okay, and that's the important thing you have to keep in mind. So it's only Rich Green that reports that there were deletions. The state disputes that. So we'll find out at trial. So Jason had the question. Kevin, do you think Judge Bev releases do you think if Judge Bev releases improperly that it could cause a mistrial? That's a question for a lawyer, but I think it would, let's put it this way. It wouldn't cause a mistrial if she releases this after the trial, right? But it looks like she's expediting it now. So she does plan to release it before the trial. And I'm going to guess that possibly, knowing how the conspiracy talk has been, you're suggesting that she's going to deliberately get a mistrial here. And I don't believe that. That would seem kind of hard to believe to me. But whether she's on solid legal footing, but she did seek the opinions of both sides, and they all seem to agree that she has the right to release this material. We don't know what was said in the federal letter. So, but she said there's no case law that prevents her from releasing that material. So I think it's going to be, I would be very surprised if that causes a mistrial or anything like that. If that makes sense. Again, and I'm not a lawyer, so, we need lawyers to check in on this, but it's been hard to get lawyers that are criminal lawyers to check in on this case in any kind of an objective way. People that have actually looked into the case a lot. It's really, really difficult. But I would suggest we look at, go to lawyer Lee. I don't know what she's doing tonight, but hopefully she might be doing something on this case. And she does do an objective, kind of fair analysis. She's not deep into the weeds of the evidence on this case, but she's a good lawyer that can give you a both sides analysis of the legal issues. All right. So Jay says, Kevin, what happened with the Globe and Morrissey working together? This is going to get you really bad in the end, buddy. Well, we'll see, my friend. We'll see. I mean, you didn't really think that the Boston Globe was going to come out and say we've been sent here by friends of DA Morrissey. Is that you didn't really think that, did you? I mean, I have no evidence of there being a connection between Morrissey's friends and this, but this is how it works. It's going to be a subtle effort to try to get to the truth. Let me just interrupt briefly to take this call because this is from Bill Noguera in prison, and I've had trouble getting.
Global Tellink, you have a prepaid call from
Williams A. Noguera.
an incarcerated individual at the California State Prison, Corcoran,
This is
California.
this is what it sounds
Call
like.
and your telephone number will be monitored and recorded. You have a prepaid call.
We'll be right
Do
back
not
to the Karen Reed case in a moment.
call. To accept this call, say or dial 5 now. Thank you for using Global Tellink.
Hey, Kevin, how you doing?
Hey, Bill, very good. And I just wanted to tell you, I am live right now, so other people can hear you. But I wanted to take the call because we had trouble connecting this morning when you were calling. I think it was on the prison systems end, but so we are live right now. So what's up? What's going on?
Well, I just wanted to call to confirm our talk this afternoon on the live show for about the Evansdale case.
Yes, absolutely. We will be on, and so I will hear from you at 5:45, right?
Exactly. Yeah, always like to confirm, make sure we're ready to do this very important case because it's been far too long since these victims' families have suffered through this ordeal. And it's time to get this case some more national spotlights.
It really is. And I found some more fascinating evidence on it last night that I want to tell you about. I probably won't be able to tell it to you, to talk about it with you live tonight because some of this stuff is personal detail stuff. So we'll have to connect together later in the week. But yeah, I really think this is a case that we can make a difference in.
Oh, fantastic. I look forward to it. Yeah, well, I'll let you go back to the live show, and I will be back with you at 5:45 this evening.
Okay. Thank you, Bill. I look forward to it. Thank you, man.
All right. Take care. Bye-bye.
All right, guys. That's Bill Noguera. You probably couldn't hear it very well there because I didn't adjust the microphone. So you'll hear it better at 5:45 because I will adjust the microphone so it'll be nice and loud. But this is Bill Noguera. He's been in prison for 40 years, basically a little more than 40 years. He spent almost 40 on death row in San Quentin, very famous prison. And he committed murder when he was 18. He killed his girlfriend's mother. So he's not a serial killer. He doesn't have any of those kind of urges. There was issues. He was angry because the mother was trying to break them up. The girlfriend was pregnant. She was trying to get the girlfriend to have an abortion. Whatever, who knows exactly what happened, but it was not because of an urge to kill. And he's doing the time that he deserves. But this is a really intelligent guy, and he wants to use that intelligence and everything he's learned to try to make a difference to help solve other cases. So anyways, we'll come back to that after. And so Jay was talking about the Globe and Morrissey working together. We're never going to have evidence of that, Jay. Maybe years from down the road, someone will dig that out, but that's how behind the scenes work go, and so you'd have to read into what they were asking for and say, did it seem like that they were doing that? And to me, it's absolutely. Now, I mentioned before the show, it was going to be subtle. It's not going to like they're going to come out and they're going to say, we demand to find out exactly what the feds were doing. But there were some hints in it in what they said. Let me see if I found it. They were focused on, they wanted to hear the defense's motion to dismiss, but they seem to be particularly focused on the opposition to that motion and whatever information is going to be in that. But, and they mentioned that the defendant has not opposed it. So it's very fascinating stuff. obviously, as far as what they're doing, we're left to speculate why the judge entertained this so quickly. Why is the judge entertaining this motion a week before the trial and trying to rush this stuff out? It's amazing. It's amazing stuff. So there are just legitimate, objective, both sides kinds of legal issues here, right? That regardless of what we may think in this particular case, what is the right thing to do in terms of making public something that could influence public opinion, which could influence the jury pool, right? So they also made a point. This was important too. So one of the arguments, the legal arguments that the Globe emphasized was about jury instructions, and that jury instructions are generally considered to be enough to overcome some of the prejudicial material that they may have had. So in this case here, what they seem to be talking about was if these motions are released, and in particular, like I said, it seemed to me an emphasis was on the state's opposition. If that stuff is made public before the trial, does that influence the jurors in any kind of an unfair way to the defense? And they were basically saying this is something that the judge can take care of with the jury instructions, and basically telling it will be fascinating to see these jury instructions when they tell the jurors, okay, you may have heard things about this case, but you need to put that aside and listen to the facts and the evidence presented to you by both sides. And so it's really interesting. And that's true, right? There's no way there's no way you're going to get 12 jurors, 14 jurors inside Dedham. So near Canton, the town where this happened, the center of all this storm. There's no way you're going to get 14 jurors that have heard nothing, that haven't seen the news. There's been, increasingly stories on the local networks or in the Boston Globe or in the Herald. So there's no way you're going to get a perfectly clean jury. People have been influenced. I think what you want to do is try to find people that have not participated in the fight. So I would want to know, I would want to know to prospective juror, have you posted anything in social media regarding this case? And if they have, they should be eliminated. Tequila Mockingbird said Brian Albert isn't a witness. Well, not sure what you mean by that, but he was absolutely a witness of course he's a witness. I mean, because anybody that was at the Waterfall pub was a witness, because that's part of the case there, because they're talking about the behavior of Karen and John and whether they were what kind of drinking was going on, whether they were fighting. They were all witnesses for that stuff. And then in the federal grand jury, I presume he was a witness. They wanted him to say whether or not John came in the house. So of course he's a witness. Tom said, how often do you get a plug from a lifer? Yeah, the thing is, it's hard. I can't call him back. So communicating can be difficult. It's turns out to be more difficult in his situation than it was for Aiden's. So there is a system where I'm supposed to be able to message him back, but the system is so faulty that even though I'm logged into it, I have not been able to make that connection. He has a wife who lives in Tennessee, like a lot of people covering this case. So Tennessee seems to be a hotbed for true crime interest. And so all I can do is message his wife and say, can you message Bill? And I don't want to, obviously she's a nurse. That seems to come up a lot in this case too. I guess nurses are really interested in true crime. So good for them. She's obviously didn't know Bill before he committed murder. So she met him because of her interest in true crime and developed a long distance relationship. Kimberly McGuire says, Thomas, Lawyer Lee. Yes. Lawyer Lee's a good show. Judy, hi, good to see you. Hope Marlene is doing good. Confident Joy says, why did Karen have to use the Signal app? What was she hiding? And from what was she hiding it? And she used it with Aiden, and she's used it with Sean McDonough. So you can, Karen's, at a minimal, you can say that Karen is extremely actively involved in her defense. I don't think anybody would dispute that. Antiquated Rogue, what's the weight of today's ruling for public consumption? I don't know. We'll see, right? I mean, it looks like we're going to see. I mean, in a case where almost everything's been impounded since this summer, now we're suddenly going to see these motion to dismiss, which was built almost entirely on the Fed, on whatever they got from the feds, and the opposition to that. So, but I just think we have to realize it's the opposition stands to be very interesting, but also limited, because all they have to do, the motion was based on, the motion to dismiss was based on an Odell. So all the state had to do was show that any evidence that the feds collected could not have been given to the state grand jury. That's it. So they don't really have to get into the weeds on the federal evidence. They will at the trial, but in that opposition motion, they probably did not, and there's no reason why they would. So I think we shouldn't get our expectations too high that we'll learn that much from these motions, but we will definitely learn some interesting stuff, because the motion was linked. The motion to dismiss was lengthy, and the opposition was lengthy. I forget the exact link, but they were described in court in one of the other hearings. Melissa says, I love that Kevin streamed Young Jerks. Yes, and I gave him proper credit. So Mike Crawford channel was Young Jerks, and first I went to Fox News, Fox 25, and again the volume was terrible. Then I went to the Grifters channel, the volume was terrible. But somebody posted actually on the Grifters channel in chat that when I was over there briefly, I saw that somebody posted that Young Jerks has good audio, so I switched over to that. So if he doesn't like it, he can sue me, or he knows where to find me. Kevin, this is a good question from Jason. There's two Jasons here, so this is Jason 169. Kevin, do we know if the prosecution handed in the certification so the defense can comply with their witness evidence list? Did the defense comply? So I don't have any information on that, but just it's a great question. So the way it works is through discovery, both sides have to have access to any information collected by the other side and any witnesses they're going to use. But the prosecution has to complete theirs first before the defense is required to hand over theirs. And the prosecution had been waiting on that DNA evidence from Bodie Lab. It sounded from the last hearing like there was basically the judge was going to dismiss that, because it wasn't certain they were going to be able to get useful evidence, and they were definitely not going to be able to get it in time. So now we haven't seen anything on that, but I think it's fair to assume that there was probably a motion to dismiss that, or it's been ruled out in some way. And so once that happened, the state would presumably be done with their evidence and file their certificate of compliance and send it over. And then the defense has to then send back everything they have. I don't know what the rules in on how long it takes. Obviously, with the trial coming next week, it's going to come pretty quick. I don't know what's in that. The only thing I do know is the camera footage from Karen's parents' house in Dighton. They had a Ring video system there, and that had been withheld. So, but everything had been withheld. So I'm not trying to say there's anything suspicious about that, but we know that exists. And so we don't know what's on it. State doesn't know what's on it. And so we'll see. I don't know what other evidence. I mean, so they would have to file anything that they intend to use. So I guess reports compiled by private investigators, if they intend to use those private investigators, by experts like, say, Rich Green, things like that. So I'm not sure what, most of the evidence is compiled by the state. Melissa says he streamed it to hear the hearing. The glare is now streaming for Kevin to interpret it for him. He's not actually streaming me, is he? Hillbilly Nitro, who's done a lot of great work for us recently, helping us out, trying to get to the bottom of things like the taillight. So he says many people out there that couldn't care less about Karen Reed. Yeah, I mean, yeah, well, the majority of the public has. I've gone through this before through some of my treatments and stuff, and I would people say, "Well, you just make small talk." The nurses and technicians. So, what have you been doing? And I end up talking about that I do a podcast, and they ask, what are you covering? And like, in fact, I would get this answer a lot. Oh, I love true crime. This is from someone at Mass General Hospital. And I'd say, oh, okay. Well, one of the cases that I'm covering is called the Karen. It's a big local case from the trial of Karen Reed. And invariably, no one ever heard of her. No one ever heard of the case. Even people that are in Boston, work in Boston, live in the area, and are into true crime have never heard of Karen Reed. So it's definitely going to be not hard to find the majority of the jurors are not going to be people that are free Karen Reed people or on either side. The majority of the jurors are just people that have their own lives and they're not that interested or not that aware of this stuff. But to find someone that's completely unaware, or to find 14 people that are completely unaware, is not going to happen. But a real issue is, again, I've posted recently on Twitter, Turtle Boy is not an ally of free speech. And really, very few of those people on that side are. But Turtle Boy definitely is not. Because his approach is to anybody who even questions things, who even just asks questions, to sick his mob on them, to try to silence them. That's what he does. That's the basis of his power, is that he has a mob that terrifies most people. Because in this day of social media, it's easy to find that embarrassing picture or that embarrassing piece of information or someone to say something about someone you want to destroy. And when you have thousands of people that are now part of your mob that's been built over years, it's easy to find that dirt, and you can use that to control people. And what are you trying to control? You're trying to control their free speech. You're trying to silence them. And they do this now. So, for instance, as soon as the Boston Globe story came out this week, which really it got everything accurate and didn't really say anything against Aiden, but they didn't like it. So now they start trying to dig into all kinds of background information on the writer, Danny McDonald, and they're going to try to threaten him. And they are not about free speech at all. Now, what we're going to see next week and over the next several weeks, they're going to try to dox the jurors. They're going to try to intimidate the jurors. Make no mistake, that's what they do. That's what they are. They are a mob. And yes, mostly a mindless mob. Mostly a mindless mob. There's no question about it. I mean, his power is built on the ability to smear people. That's how he gets his scoops. That's how he silences people. And he's become so emboldened in it that he thought he could just this past summer by now, that he could just run crazy. Because that power, it's a tremendous power to be able to silence vast swaths of people. They had a hard time finding a special prosecutor that would take it on, because all the prosecutors didn't want to deal with that mob. It wasn't worth the effort. So for anybody out there who thinks Turtle Boy stands for free speech or justice or truth, no, he's the very heart of what opposes that. If you stand for truth, you stand with anybody who is sincerely asking questions on both sides of something that is unsolved. Okay, here's a case here where you have a very unlikely conspiracy. Okay, and that's what we were looking at this case back in April when the story first broke. It's very unlikely to have a conspiracy where you have to keep so many witnesses silent and have so many officials participate in it in some degree, including planting evidence. So without knowing anything else about the case, you start right there and you say, just common sense, that is unlikely. Okay, now, not impossible. That's your starting point, that it's unlikely. And so, and you also say, so when someone is going to put out, who is putting out that theory? It's the defense team. Well, then you ought to be suspicious. You ought to be skeptical about that. Again, not dismissing it, but as your starting point last April, you should have been, first of all, you should have understood when that theory emerged from day one on April 18th, an entire theory that was all intricately crafted together, showing Colin as as they fingered as a suspect and as the murderer, and showing pictures of him with bruised knuckles and everything else that was in that. You don't think Turtle Boy, you couldn't have thought that Turtle Boy put that together on his own, right? You had to have known that that was given to him intact by a defense team. You had to know that. It's just common sense. That's where I was back April, even when I was new to Turtle Boy and new to this case, and thought maybe there might have been a conspiracy because 227 is such a powerful piece of information that looking at that, you say, well, there must be a conspiracy. And we found out later on that the state wasn't accepting that at all. But back then, you're thinking, well, it's just data. And if Jen McCabe had made that strange search while her friend just happened to be supposedly unknown to her dying out on the lawn, then you'd say, okay, well, there's something happened here. Okay. But even with that, you should have been looking and saying, this is suspect. Let's keep a skeptical mind here because you're getting this case intact entirely from a defense team. And every aspect of it made it very, very unlikely. Like I said, then all the witnesses and all the people that would have to keep quiet, involved in some way, the medical examiners, the first responders, the local police, state police, the emergency room staff. That's a lot of DAs and prosecutors. That's a whole lot of people that have to participate in some level in that conspiracy. And you should have been like, okay, this is a lot to ask for. Okay, I'll keep an open mind because strange things happen in the world. And then as the summer rolled by and you saw the way they were behaving, you should have been saying, this is wrong. This is you're calling up people and screaming at them, and you're harassing them outside their business. You're accusing them of murder. You're taking a Boston cop and chasing him down to his car and circling him and accusing him of murder or defending murderers. Just a normal, everyday human being sense of decency should have told you that was wrong, that behavior was wrong. And to see the number of people that were enjoying being part of that mob and going after those people, you should have had some hesitation like, Jesus, is this really the right thing here? But by now, at this point, if you don't have any hesitation about the way he acts and the mob that he's created, because it's not a personal thing between me and Aiden. I could care less. I don't have any feelings towards him one way or the other. I really don't care. He bores me. But the phenomena that he has created is dangerous, and it will continue after this case is over if it's not stopped. And the only way to stop it is to have most people recognize it for what it is and ignore it. That's the only way. Because I don't believe in having a heavy-handed government that's prosecuting people all the time and stuff like that. There's a role for that here. There's no question that there was a level of witness intimidation. There's a role for that. But, the main way that this has to be stopped is from regular people thinking better, having a better sense of decency when that's something that's a phenomenon that's going on that's dangerous and is wrong and is unfair, and people doing a better job at weighing evidence. I'm sorry if that sounds bad, but people have to do a better job at weighing evidence. If there was no way to plant evidence, if there was no access to Karen's SUV, then the rest of the stuff in the case just becomes odd things. And there are odd things in every case. So let me get through a few more of the questions. Sorry, I got behind. Tom reminded people to hit like. Black Laws Dictionary. I don't know what that is. Will says that many people are not interested in the case. Yep, absolutely, because people have and once the conspiracy is dispelled, it becomes much less interesting too. Other than this phenomena that's been unleashed is always going to remain interesting in this day of social media, because now all you have to do is have a defense team manage to get social media on their side, and social media is very vulnerable to conspiracy. Jay says, imagine calling this a podcast. It's just you yelling at other men that are much better than this you. Well, some of these guys are definitely more entertaining, but they're not better thinkers. They're not objective, and they're not honest, and they have no integrity. In almost every one of those cases, they don't. There's a difference: is they don't care about the truth. And let's be honest, Jay, you don't either. But I'm glad you're here, because eventually some little part of this common sense thinking might slowly wash off onto you. Then he says, Kevin, you're such a liar. This is a laughable, and you're already viewed as a clown. Viewed as a clown by free Karen Reed zombies. Some of the dumbest fucking people in the state. I mean, it's just listen to their conversation. I mean, it's unbelievable. Listening, and the grifter's not even from this state, but just listening to him the other day in that little clip when he was trying to, now that we've showed with the help of people like Hillbilly Nitro that Karen Reed's taillight was in pieces early that morning, and that's beyond dispute. So now he's going to come out and say, well, I never cared about the taillight anyways. I disagreed with Sean. That was never that important. But then literally when instead of explaining to his audience why the taillight is not important, he went on for 30 seconds, and I kid you not, you can go back and watch this, and I have the clip, but he goes, he literally, he had a 30-second brain fart because he couldn't think of why the taillight wasn't important. Those are the people that do it better than me. Well, they make more money at it because there's a lot of stupid people willing to pay money for that shit. Tequila Mockingbird says, I'm just concerned now that TB is going to go after the jury members. Yeah, they're going to try to intimidate them during the trial. They're going to try to intimidate them, and they're going to make clear that they're going to go after anybody that doesn't vote the way they want, because that's what they do. And it's what the extraordinary thing to me is that there are thousands of people that support that aren't bothered by it. And I don't really see any difference between that and the Salem witch trials. I don't really see any difference. It's all about power. Will Scott said TB is a 5'6". I don't know what BOI stands for. Boy, I guess, with a megaphone. I don't think he's actually 5'6". More like 5'5". Jay says, I'm not a total redhead, though. Well, you tell me which source that you follow. Okay? Because we make it easy for you. A month from now, you're going to be like, holy shit, that guy Kevin was right. I should have just stuck with him. Trust me, brother. My analysis is way sharper than theirs. And if that sounds arrogant, I don't really give a shit, because it's not just me. There are tens of thousands of people around this state who have jobs and who are intelligent and logical and have excellent critical thinking skills. Those are the kinds of people that will be on the jury for the most part. And they will have no problem understanding this evidence just because you do, or you have some deep personal need to want to believe in this case. What can you do? But stick with me, brother. I'll get you through it. Esoteric Empire, that's a cool name. TB is going to be doing years in prison in protective custody on suicide watch soon. I mean, I don't wish for that. I never wish for anybody to go to prison, and I don't think years would be appropriate, because as much damage as he's done, because he has absolutely no conscience at all, or no integrity at all. He doesn't care about his audience. He lies to them all the time. But he's not a violent person. He's not dangerous. So even though he's done a lot of damage to innocent people, I don't think it's appropriate to send a non-violent person to jail. Someone who hasn't really committed any other crimes before this, right? I mean, I don't think it would be appropriate to send someone like that to jail for years. That would not be the best result. Jay says, Kevin, all that is the truth. Levy and the feds are indicting soon. How long do you plan to cling to this fantasy? Okay, we're a week away from the trial. Are you saying that the feds found evidence of a conspiracy and held it back from the parties? If that's the case, they're going to be up for charges themselves. If the feds found evidence of a cover-up and they did not give over that information to the parties a couple months ago when they gave over their information, wouldn't that bother you? What would be the reason for that? If you either give nothing, but once you agree to give over what you have, because some of that information might be exculpatory or inculpatory, then you're going to give over everything you have. You're not going to hold back some big scoop, some big piece of evidence that blows up the conspiracy. I'm the McAlberts. No, you're not going to do that. So it's crazy. It's not sane. The thinnest thing you could cling to is that there's some piece of evidence that they have not discovered yet of the conspiracy. But the problem with that too is that we now know from the indications in these hearings, and we'll know more once these motions are made public, that they got evidence. They had the communications from everybody that was accused of being a part of the conspiracy. They got the data. So yet they didn't find anything. So they dug deep and hard. I mean, they grilled all of these people in front of a federal grand jury. They talked to all kinds of people. So to believe that they didn't find anything yet is kind of weird. Tequila Mockingbird says she got banned from TB's Facebook group just for saying that the injuries on John's arms don't look like dog bites to me. You know, later in the summer, I had joined the initial justice for Karen back in early summer, but I was never participating in it. I just would go in there and check it out once in a while. I never posted it until when somebody in late July named Arod put an attack thing up on me. Maybe it was in August, put up an attack post aimed at me, and hundreds of Free Karen Read zombies chimed in saying there's something wrong with him and this and that and blah blah blah. Why don't Dave and Aaron get their own channel? That's when I finally started kind of fighting back a little bit in social media. I'm not the type to just sit there and take it when the zombies come on the prowl. And so not long after that, Sean actually was in charge of the group at that point. And I had just posted something respectful that was both sides. And he sent me a message saying, Kev, I'm sorry, but I'm going to have to kick you out of the group because nobody should be here that's not sure Karen is innocent. And then, so I had no access to that group. And similarly, when Turtle Boy set up his group, I didn't have access to that. But I said to someone who was communicating with me that was more on the fence at the time they leaned conspiracy and then have now gone mostly the other way. But I said to her, I said, you know what? I said, to give you an idea what kind of people are in that group and what kind of people run it, put up a post saying essentially, hey, I believe Karen Read is innocent, but I have these questions about the conspiracy theory and the attacks on her. She put it in there, and the attacks that came on her were very revealing. So even though she started out by saying, I 100% believe Karen Read is innocent, but I have questions, she said, that was enough to trigger them. So yeah, that is a mindless mob. They're not after the truth. They never have been, and they probably never will be on any case. If you want to hang around with morons, that's the place to go. Okay, guys, we'll stay on a few more minutes. I'm trying to get caught up on the questions, going through, making sure I'm not missing too many. Nicole Beaver says, Kevin, I'm pissing my pants. Sorry for yelling. That literally made me cackle. That's exactly what I said. Only total riders and free care and readers feel like that. So that was 10 minutes ago. So I don't know. One of us said something funny, either me or somebody in chat, but it's good to make people laugh when you can do it. That's why I have a little fun with those AI generated images. They might piss off some people like Young Jelly, but I think some other people will enjoy them, get a good laugh out of it. Tracy says they will never admit to being wrong. If she loses, they will just scream corruption. Yeah, and that's the thing about this. It's like those cults that say, the end of the world is coming on June 13th and the mothership will arrive. So make sure you're at Lookout Mountain just in time if you want to survive the apocalypse. And then the crowd of cult people gather, and then the spaceship doesn't come and the earth doesn't end. Well, what do? Common sense would be like, wow, we got duped. But nobody wants to feel like they got duped. It's, the sunk cost theory. Once you've bought into something, you don't want to feel like you can't, you don't want to feel like you wasted all that emotional energy. So then when the cult leader comes out and says, oh, I'm sorry, I got the date wrong. It's really September 13th. I got my analysis, the entrails that I analyzed were just a little bit off. Well, most people in the cult are going to go, oh yeah, of course, it must be September 13th. And you could probably get away with that several times before some of those people finally wake up. And that's what it'll be in this case. If Karen Reed pleads, or if she is convicted. Either way, the people are going to just say, well, now they got to the feds. You really think Sean is going to suddenly come around and say, okay, I was wrong. Let's take the L, as he likes to say. No, he's always making predictions. They don't come true. And then later on, he just makes another prediction. And each new prediction is more absurd than the last. He's never going to give it up. He's never going to give it up. Sully gave a super sticker. Thank you, Sully. Appreciate the support. And even the small amounts mean the same to me because it's that token of support. Because you get, as you can imagine, I get a lot of, let's just say, lack of support sometimes. I get a lot of attacks. All right, I pretty much had it with you, Jay. You're just not smart enough to gain my interest anymore. This is not the other Jay, but Jay, the one who's just going under as Jay. Just there's a lot of dim bulbs out there, and there's not much we can do to brighten them up. And Tracy said, my favorite motto, stand up for what is right, even if you're standing alone. Thanks for doing what is right, Kevin. And that really sums it up. And I've talked about it before, but again, my approach to this is there's different things. One thing is everybody has a potential to suffer from that sunk cost theory or confirmation bias. So I want to check myself every day, certainly every podcast, to make sure I haven't managed to dupe myself because you're trying to buy into a theory that you've based on conclusions that you've already made, or trying to filter any new evidence or any new information in a way that reflects your bias. And so I work very, very hard to not do that. But it is part of my nature. I've done that all my life. So it's second nature to me to question my own presuppositions, my own motives. I'm just a billion things in life that I'm not good at, most things, but I do look deep into myself all the time, and I think that that's helped me do more logical analysis of these things. It doesn't mean I'm not going to get things wrong, but I am sincerely always trying to give people objective analysis and look at each piece of evidence objectively, just like I did today with today's hearing. So, I mean, I didn't come out and say this proves this or this proves that. We don't know. It's going to be, there's different ways to interpret. So the judge clearly wants to release this stuff before the trial. What does that mean? What does that mean? I don't know. It's amazing. Neither the defense nor the prosecution have opposed it. We don't know what the feds chose not to send a representative, but we don't know what they said because they did send a letter, and the judge didn't reveal that. But it's clear that the feds do not have the power over her court. They just don't. So, legally, she has and she's not bound by the protective order that the parties were, that the defense and the prosecution were. So she has to look at state law, and she has to look at a sense of fairness. Sailboat Wolf says, pretty sure the judge wants this release to counter the PR campaign. I am inclined to agree, but it's so hard to tell, and the judge would have to be so careful on that, because it's appropriate for judge to try to limit a PR campaign, such as advising that these press conferences they used to hold on the steps of the courthouse after a hearing, to knock that stuff off. She seemed to be somewhat harsh against the district attorney for his press conference or his statement that he read in September. But so for her to actually want to counter, like weigh in on the other side, that's tricky, right? She may think that there's been an unjust influencing of this trial based on the very presence of the federal investigation and what the parties have talked about in the hearings. But I don't know, is the remedy for that making these motions public? Well, apparently it is. But it's really, really interesting that she pushed to do this at the last second. That's just it's stunning. We don't know when the Globe first sent this, but I'm guessing they recently sent for this motion. So I don't know. Paisley Doodle says he had a whole show on us last night, Kevin. I'm not sure who the us is. I'm not sure who the he is. So, but there's a whole lot of grifting out there. To me, again, I've talked about this before. Grifting doesn't mean just, if you set up merch or take donations, that doesn't mean you're grifting. To me, if you just don't care about the truth and all you care about is selling your merch and you're willing to sacrifice truth on that altar, that's what grifting is. When you don't care about who you smear, that's what grifting is. You're not interested in justice. You're not interested in the truth. You're not interested in fairness. You don't care. You have no ethical standards. You don't care what you do as long as it gets you views and subscribers and donations and sells merch. And I just, unfortunately, am seeing that with the majority of channels. What software do I use? Lately, I've been using this one called Ideogram, and you get like 25 free ones a day. But there's also a free software that comes with Microsoft Bing's Copilot. That one can be pretty good, but it's not as good at putting in letters. So if you want to put in a banner that says FKR, it can do it, but it's not as good at it. But the bigger problem with it is it's got so many politically correct safeguards in it. Like it won't even accept the word zombies. So if I put in show zombies in front of a courthouse, it won't do it. It gets a violation for that. It's violated some of its rules. Zombies, I mean, come on, that's crazy. I understand. So, but this ideogram doesn't really. I haven't seen any warning. I haven't seen a single warning come up with it. Now, I haven't really. I don't know. I haven't specifically tried to test the boundaries on that, but I put up a lot of zombies and stuff, and it has no problems with that. Oh, I actually got to the end of the comments. Excellent. Norwegian Troll, have they sent the letter to you, Kev? Well, I'm not sure what letter, but nobody has sent me anything. And I don't have access to any kind of privileged information. I get it just from other sources that are following this case, and they send me out the documents and things like that. But definitely no, I wouldn't want anything that would jeopardize the case or any kind of impounded material or anything like that. I don't push for that. I don't get it. I don't have any contacts with the prosecution. I don't have any direct contacts with anybody in law enforcement related to the case either. So in fact, I do have some pretty good contacts though that are good sources, and I can say that nobody has heard, or at least has told me that they've heard anything about a plea deal. Nobody is. So now I've always said that I believed that there would be a plea deal that Karen would seek, and that this would come at the last moment. And I didn't. And to me, we would not hear anything about it until the last second. So is now that time? You have the trial is next Tuesday. You can work out a plea deal right up until the jury actually delivers their verdict. You can even technically, even if the jury goes into deliberations, technically both sides can still work out a plea deal. Now that's probably pretty rare for it to happen at that late of a time. But so I would think this trial technically starts next Tuesday, but there's probably going to be 3 to 5 days of jury selection. So it probably doesn't actually start. The prosecution won't present its case for at the earliest at the end of next week, but probably not till after that. So there's still plenty of time to work out a plea. I don't know how long that takes. I don't know when those discussions would begin. But I myself have not heard any, and I've reached out and I haven't heard any rumblings of any plea negotiations. I've seen all that stuff on Twitter, but I don't report it because I don't hear anything from a credible source saying that. So that doesn't mean it's not happening, because it's something that will be kept very secret and should be kept very secret. Caitlin pays $20 a month for Copilot. Oh, I mean, so I got the Copilot with Microsoft's Copilot free. It just came with an update. And so if you guys have the latest version of Microsoft's Bing, in the right-hand side, there's a toolbar that has a bunch of different useful tools on it. It also put links to some websites that you frequently use, but there's a Dropbox kind of connection. There's the image creator. I'm looking at it now. There's Outlook, Microsoft 365 games. So a lot of it's just standard Microsoft stuff. There's a toolbox. But I just stumbled across the image. There's other image creators that are free that work pretty good too, but it changes. So the ones that I was using a year ago to make thumbnails and stuff, those have not caught up. So someone's always going to move ahead. There's a whole bunch of those, and really even every graphic generator now has some kind of a free image generator in it. So, but someone always moves ahead. So some of them can make short videos too now. But they usually like 4 seconds. There's a couple I think that are now got a little longer than that. So Caitlin got the premium. I don't know what you got for the premium, but I already pay for enough things related to this channel that I seek out the free apps like that. So, I mean, I pay $50 a month for this StreamYard. I paid $16 a month for Twitter. I pay $35 a month for Adobe mostly for their editing software. I don't forget, there's a couple other things that I have to pay for, and it adds up. Oh, it's Karen from Is this True Crime and Wine? Hi, Karen. Glera did a whole show on us. Man, we haven't even been on the air together. We've only went on the air together twice. Once was with Matt, and once was with me and you. Because you've been avoiding me going on the air, but going on the air with me. Anyways, I don't watch his channel. I mean, and you could see why from the clip that I showed the other day. It's too stupid. It's a waste of time. It's so stupid. Actually, the hearing last week, it was 9:30. I wasn't feeling that great. I had a lot of stuff going on, so I figured I would just watch his channel because I knew he was covering it instead of streaming this live. And then, so I went on his channel at 9:20. I turned it, but because I was doing work on another browser, I had to keep the volume open on that to listen to him. As I put it as low as I could, but the stuff he was saying was just so stupid that I said, "Fuck it, I'm going to go cover it." So I went upstairs. I went up and streamed it at the last. So I got in just about 5 seconds after the Bev started talking, but it's just so stupid. Tracy said, "Just tune out the rest." Yeah, usually I do. I don't watch those shows. I would watch it if they had important information, and I don't watch Young Jerks. But when I saw that he had good volume on the hearing, I went there and hijacked his feed. So thank you, Mike. But giving him the free plug too. So next time, maybe he'll have the good audio. But it's been unreliable. It always moves around. The last hearing, the Glera had good audio. There's been other hearings that I've had it. So it's frustrating that the audio has been a real problem. How do I like the Twitter Premium? I like it because I get to you don't have a limit to the length of your post. That's all I use it for. So you can use a post for it. So I basically turned it into my WordPress, and so you get to slog your way. Usually I have one long post a day that I write in the morning. So, all right, guys. One more question, and then I'm going to head off because I am going to be back on about 5, and we're going to go over the Evansdale murders. These took place in 2012. They're unsolved. Those girls would be in college now. They'd be, I think, 20 and 22. It's a case that really bothers me, but the reason I want to work on it is because that killer is in all likelihood still alive. And there are circumstantial elements to this case that mean they should be able to find this killer. Now, I did not follow the Delphi murders until a year and a half ago when someone asked me to. And this is before Richard Allen had been caught or had been identified. So he was not on anybody's radar. But I didn't understand why they couldn't have just caught this guy within a couple of weeks or less back then, because you have some things in a small town that make it easier to whittle down your list of suspects. So Delphi is a little under 2,000 people. Same with, I think, Evansdale that we'll be covering today. But and then in the towns around Delphi are even smaller. Like some of them I call them towns, like they're villages with a population of 5. So it's an extremely rural area. You have to drive about 20 minutes from Delphi to get to the next sizable town. And the Monon High Bridge and the trail is something that would be known to locals. And because of the way the girls were led across the creek and led to an isolated place along that creek and where they were slaughtered, it's always been known that the killer had to have been someone that was probably a local. Either he lived in Delphi then or had grown up there or spent enough time there that he knew that area. It's not on a highway. It's not the kind of thing where somebody would have got off there, and it was unlikely that they would have figured that out. So now you got a list, not a certain list, but a list of 2,000 people. And then I use ChatGPT to figure out that. So we're assuming the killer will be male in Delphi, right? And based on witness descriptions, we could get, well, they had a range, but basically between the age of 25 and 50. Most of the witnesses had seen someone that they described as being in their 40s. And then there was the FBI had put out or the state had put out later on a composite that said he might be as young as 27. So what I searched for was witnesses that were, for suspects, residents of the town that were male, that were between the age of 25 and 50. And the number that came up was 500. So that would be an excellent starting point. 500 people, right? You say it's got to be one of them. It doesn't have to be. There's a chance it could have, but very good chance that it's one of them. Can you narrow down the list anymore? Well, it turns out yes. So they had a pretty good partial description of the vehicle, that it was a dark, small SUV or sports type vehicle. So basically some kind of a dark hatchback kind of vehicle. And so you could look at that and say, of these 500 men who are in the right age in Delphi, how many of those people own a vehicle like that or had access to a vehicle like that? No, I don't know the numbers on that, but I would guess that could get your information down under 50, right? Certainly under 100. So now now your list is down to 100 people, and you've done this in just days because you had enormous resources. You had the FBI, you had the state. Well, then you look at that and you say, just now you start looking at those specific suspects, find out who was at work, who had an unshakable alibi because they were out of town, or maybe someone's handicapped, so they couldn't have been walking along that bridge. And you start crossing people off your list. And I think just going through that, you would have got that list down to, at the minimum, 15, and maybe lower than that, right? So let's just say conservatively 15 to 20. So now you've got a list of 15 to 20 men who were age 25 to 50, who were white, who were not handicapped, so they were able to walk across a difficult bridge and across a creek and down a hill and all that stuff, and who drove or could have had access to a type of vehicle that was witnessed. Well, when you look at that, one of the things that you can do is say, all right, so now we've got our suspect down to 15. Now, one of the witnesses had seen the killer. We now know it was the killer, but at the time it had to be presumably the killer, but walking along the road besides the trail, covered in mud and blood, looking like he'd been in a fight. That's what the witness said. So you knew that this killer was going to go back to his car. They knew where it was parked, and he was going to get into that vehicle covered in blood, which they would have known even if they didn't have a witness, because he slaughtered those girls with a blade, and there was enormous amounts of blood at the scene. So there's no question he was going to get quite a bit of blood evidence inside that car. And even if he takes it home and spends hours cleaning it out, you're never going to remove all that evidence. And so all you got to do is take a can of luminol and spray it in there, and you'll find the blood evidence. So what I said they should have done was take that list of 10 to 15 or maybe 20 people that were in that age range, lived in that town, and had access to a vehicle of that particular color and general type, and go up to them and say, we would like your permission to spray this luminol inside your vehicle. And I've talked to other police, including a federal investigator, who says you'd be amazed, but most of the time, even the main suspect, even the guy who did it, will say yes, because they feel like if they say no, the jig is up. That exposes them. But so let's say of those 15 or so people, let's say 10 of them say, yes, you can search my vehicle with that. And most of the people in the town, if you're innocent, you want to do everything you can to help out. So the cops spray the luminol, they don't find anything, and they clear that person. So now you've got a list of, say, 5 people. Man, that is a short list to work with. Now you start digging really hard and to find out where they were that day. And maybe you can eliminate some more of them off that, but find out, did an empty bullet shell was found there? Did they own a gun? There's this, how close was their physical description to what the witnesses described? So you could probably narrow it down even more than those 5 people. And you certainly have the resources to watch those 5 people and see if they do anything suspicious. And at some point, you may even have enough to get a warrant to search their house. And I think if you did that, you would have caught Richard Allen. I said that before Richard Allen was caught. I said, if you use those methods, you would have found him. And we now know, from what we now know about Richard Allen, yeah, if they had used with just that simple method that I outlined there, they would have caught Richard Allen. And I think you can apply something similar here in this Evansdale case. The town of Evansdale is 2,000 people, so similar size to Delphi. It is directly borders the larger town of Waterloo. I got to look it up before I get on. I think Waterloo is about 30,000 people. So, but there's another way to water it down, though, because the bodies were found 20 miles away in an extremely rural area, an area that nobody would have just found on their own. And the police have said, and I'll show you the images why, that whoever left those bodies there knew that area very well. The high school class for that town averages 28 people. So you're talking about a very small list of people that should be on your suspect list. So you're looking at people that went to that high school or hunted in that area, and they've already talked to all the hunters, or at least the licensed ones. So the high school kids were known to party in those woods too. So we said this a while ago. It would have to be somebody. It was somebody that was on that list, that short list of people that went to high school in that area. Now you look to see which of them, is there any other way you can start narrowing down your list? And you see which one of them might have had some connection to Evansdale, which is 20 miles away. And that connection is here, and it points right to someone, and the evidence is even stronger. I'll save that for later. When you hear it, I think your mind will be blown, but I just have to be so careful about how we talk about this case because I don't want to. There is no direct evidence linking this individual. So I just want to be careful how I do it. But I will leave the trail of breadcrumbs, which I've already started now. And so Bill Noguera is going to be back with me. I'll be back on around 5, and Bill will join us about 5:40. And he will have Tom, I'm just trying to see, is somebody trying to say that I'm faking cancer again? Like, these free Karen Reed zombies are just crazy. I could actually, I don't know if this matters to you, but I will log into my Mass General. And go to visits. I'll pull this up for you. Oh, mosquitoes already. Let's see if I can pull up. All right. So we'll pull this up right now for you. I mean, unless you think George Soros is creating a fake account for me at Mass General Hospital. So this is my patient portal from Mass General Hospital. Shows my most recent treatments. You see, on March 5th, I completed my 5 days of radiation. And so that was like basically supposed to be 5 consecutive, but they broke it up because of the weekend. And then actually one of the days the machine was down too. So I don't know if that convinces you. This is my upcoming appointments for on first week of May. You can see that. So they'll be scanning my abdomen and pelvis and my head. Those are all areas where I've have cancer. Patient to chemo on May 9th. So there you go. So I don't know if that proves it to you. Anyways, we'll close that. So that should prove it to even a turtle rider. Whatever. Potential scam call coming in. All right. Anyways, it just seems crazy that people even question that shit. But I can tell you, I've been very, very lucky. Olivia dropped a letter on X from Feds and Josh Levy about today. Oh, okay. All right. So let's stay on and go see this. And we'll react to this together. That's what, so that's what somebody, my friend in Norway messaged about the letter. So unfortunately, I will not be able to read this. So can somebody do me like, you know, when I can read it on my, I don't know, these are too small and there's no way to make these bigger. There's no way to download them. So if somebody's there, if you could send me, if somebody there can download the letter and send it to me, I'll go over it on the air. I can try to get it on my phone because that's something that I can expand it with, but I don't know if it's actually going to be on there. I don't know if I'll find it. So let's see. But again, if somebody has that, please right click and open a new tab. All right. But you still can't really, you can, I can expand it a little. All right. Okay. That's good enough. Thank you. We'll pull that up here. Hold on 1 second. Take just 1 second. Okay. And let me get myself off the screen. This is my first time reading this. So this is from the U.S. Attorney's Office. The United States Attorney, and keep in mind, they have skin in the game here. The United States Attorney's Office received a copy of the motion from the Boston Globe, and the court's order tentatively setting a hearing on the motion for today that we just heard. The court may anticipate that the United States would respond to that motion either by filing a brief in this court or appearing at any hearing on the motion. However, because the United States is not a party to this action authorized from the Department of Justice, However, because the United States is not a party to this action, authorization from the Department of Justice is required before my office would appear or file a statement of interest. I cannot say at this time whether the United States Attorney's Office would seek such authorization or whether it would be granted. Nevertheless, I write to advise you concerning the applicability of the federal court protective order. As the court is aware, to the extent the impounded filings at issue in the motion reference or include materials produced by the United States Attorney's Office, those materials are subject to the protective order entered by the United States District Court. That protective order was the product of discussions among my office and the parties to this action. Neither the parties themselves nor any third party, including Boston Globe, have sought to modify that court order. It remains in full force in effect. Wow. Well, thank you, Olivia, for posting this. I think it's amazing. And I don't know why Olivia posted it, because it really doesn't help their case at all. So it's fascinating that the feds are basically saying, we don't want any of this stuff exposed or made public. And you heard the judge. She basically gave them an FU. She said, the judge said that the feds essentially have no jurisdiction. The protective order does not apply to the judge. The protective order applies to the parties, but it does not apply to the judge. That's not at all what the feds wanted. The feds are basically saying, no, it still applies to everybody. And she said, no. It's in my court now. And nobody has raised any precedent, any case precedent that would suggest that we can't release this. So that's, wow. That's amazing. And thank you for the advice, saving it to photos. Yeah, it does have that option. Okay. But hopefully you guys can read that. You certainly heard that. But so let me bring myself back on the screen. Do you guys read that the way I read that? This is incredible stuff. This is really, really incredible stuff. I cannot say at this time whether the U.S. Attorney's Office would seek such authorization or whether any such authorization would be granted. And this is from the Deputy U.S. Attorney. Nevertheless, I write to advise you concerning the applicability of the federal court protective order. As the court is aware, to the extent the impounded filings at issue in the motion reference or include materials produced by the U.S. Attorney's Office in response to the parties, those materials are subject to the protective order by the United States Court for the District of Massachusetts. That protective order was the product of discussions among my office and the parties to this action. Neither the parties themselves nor any third party, including the Boston Globe, have sought to modify that court order. Well, the judge did not go along with any of that, did she? The judge did not agree with that at all. And this should really tell you a lot. So the judge has had it with this interference in her case by the feds. And like I said, please, just common sense, bear in mind just that the U.S. Attorney's Office is not neutral here. Okay. Now, we don't know why they're so firmly on the side of Karen Read. It's possible there was some corrupt connection, that the U.S. attorney or someone else there has a connection to Karen Read or her family or to Yannetti. But there doesn't need to be, because they have the same issues of basically egg on their face. If they were duped in the same way that Turtle Boy was duped, in the same way that the Grifter was duped, in the same way that Young Jelly was duped, in the same way that thousands of zombies were duped, if the feds were acting in good faith but were duped, it still makes them look bad, especially all the improper coordination, really, not just communication, but coordination between the U.S. Attorney's Office and Karen's defense team. It makes them look bad. It's embarrassing to them. It's extremely embarrassing. So the best way to avoid being embarrassed is to find a conspiracy and to play the role of the hero. See, This is what we do. We're out there trying to find corruption all the time, and we just found the daddy of all corruption cases. We found it for you. So even if our methods might seem a little shady to you people, hey, we were on the side of good here. That's what they want the argument to be. So they had a vested interest in finding that there was a cover-up. And now, whatever's in those documents, they don't want it out there. But they knew they had only so much power over the judge to do that. And the judge, having heard them say the protective order still applies, said, no, none of that. I'm not playing that game, because nobody has mentioned any case law that means that prohibits her from unimpounding. That's probably not a word, but Tom, forgive me, from unimpounding that material. So it looks like they're not, and if I understood the judge correctly today, they're not going to make public directly the federal material. What they're doing, though, is going to make public the motions by the defense to dismiss the case, which were based mostly on the federal material, and the opposition to that motion, which is also going to be based mostly on the federal material. Thank you, Tom, and let me know if there was a better word for that. That's fascinating. So the judge is going to let that come out. She's in a hurry to get it out. She's in a hurry to get this out. Why? It's fast. She's taken a stance against the U.S. government. So for those of you there who think maybe this material is going to help the defense, just if you're keeping score here, like I said, the feds are on the side of the defense, and the feds don't want this material released, any of it. So I don't think this material is going to help the defense. Now, it should be said, as I said earlier, if you're getting here late, neither the defense nor the state have opposed this. So essentially, nobody's opposing it, except the U.S. Attorney's Office did in their way. So this is fascinating stuff. And I wish I was a lawyer with criminal law experience or a constitutional lawyer that could explain this stuff better to you. And so hopefully we'll find out where we can get some information on that later. Yeah, Fiona, she said, read it, and said, forget it. Yeah, she just basically said F you to the U.S. Attorney's Office. Make no mistake. They've been ignoring her. They've been interfering in her murder trial. They've been potentially influencing the fairness of that trial. And she's had enough of it. We'll see what comes out in these motions. I think there'll be a lot of interesting stuff, but far from all of the stuff. And so we should get a sense, right? And then more is going to come out during the trial. Now, why wouldn't the defense team oppose this? Well, there's, logically, maybe there's nothing in it that harms them. That's one possibility. Maybe they knew that their opposition they had no basis for their opposition. They had no legal basis for it. So they knew it would probably fall on flat ears with the judge. I mean, they can't really come out. I don't think they could come out and say, well, this information could prejudice the public against my client. I don't think that would be a strong argument in this case, especially given that they've already been making a lot of this stuff public at the hearings. So they may have just cut their losses and said, there's nothing we can do here. So rather than make it seem like we're trying to hide something, let's just not oppose it. Yeah, so Will Scott said, if the defense opposed, let's close this document. Will said, if the defense opposed, even the minions would start questioning things. Well, probably not. Yeah. I would think if the handful, the 5 or 6 sensible people on that side might start to question it. There's more than that. But I don't, but yeah, the minions, no. And some of these minions at this point, they just, even if they question it in their own mind, they can't publicly question it. They have no choice. As Sean likes to say, what hill are you going to die on? He's dying on a hill. He is dying on that hill. And it's interesting that he puts it that way, because you only put it that way when you know you're surrounded. Okay. Why would you be talking about dying on a hill unless your forces are surrounded? And they are surrounded. The zombies have backed up into this little shack, Free Karen Reed headquarters on the top of the hill. Sean is manning a post somewhere in there, and it's done. It's crumbling. You can see it crumbling, and they know it. But he can feel it. But that's why he'll say, "What hill are you going to die on, Kev?" I'm not dying on any hill. I'm just pursuing the truth, and that's what everybody should be doing. But they're not. So even if things come out, evidence comes out over the next several weeks or days or whatever that reverses conclusions I've made or analysis I've done, I'll be happy to do it. I was happy to do it right there. I was reading that letter for the first time live, and I have no, if it came out to be something that ended to debunk something I had been previously saying, I would have gladly reported it. All I care about is the truth. I'm not on anybody's side. They can't say that. They have a hill to die on, and they're dying on it. So we'll see you guys at 5. Thank you.